Well, that was fun, wasn't it? Oh, yeah, I'm not surprised by that at all. I kind of thought so, that might be the issue. I think they're hedging because everything is maxed out right now. Let's see. Oh my god, not this again. Okay. Ridiculous. Oh my goodness. All right. Nothing works, and I will simply have to get used to it. Complicated. YouTube live dashboard. Please and thank you. Wonderful. So then comes the big question, like, how am I streaming right now, but the dashboard isn't open? Okay, sure. Nothing makes sense. I refuse all of this. Well, okay. Hey, at least audio sounds good. Okay, we're back to streaming now. I'm going to start recording again. Stupid tech issues. I really need to figure out at least 3 of the issues that this computer has right now. But I'm not going to do that. I'd rather just get done with this. So, Town of Castle Rock versus Gonzales. We've already read through that. DeShaney is where we were. We were reading the unfortunate, awful reality of how the child got hurt. Let's restart there. And we have also found a village. I haven't done anything. I've just ran around and got things reset back up so we can go back to streaming. I don't know why we're reading that quickly.
Used by traumatic injuries to the head inflicted over a long
4-year-old boy, life permanently altered by psychotic father.
Suffered brain damage so severe that he was expected to spend the rest of his life confined to an institution for the profoundly mentally disabled. 6. Joshua died on November 9, 2015, at age 36. 7. Randy DeShaney was subsequently tried and convicted of child abuse. 4.
So,
less than 2 years
in this precedent case, someone did in fact get only 2 years of jail?
Edit. Joshua DeShaney's mother filed a lawsuit on his behalf against Winnebago County, the Winnebago
for failing to protect his well-being,
and DSS employees under 42 U.S.C. Section 1983. The suit claimed that by failing to intervene and protect him from violence about which it knew or should have known, the agency violated Joshua's right to liberty without the due process guaranteed to him by the 14th Amendment
no right to freedom
to the
from
United
abuse.
States Constitution. Ruling. Edit. The court ruled 6-3 to uphold the appeals court's grant of summary judgment. The DSS's actions were found not to constitute a violation of Joshua DeShaney's due process rights. Court opinion. Edit. The court opinion, by Chief Justice William Rehnquist, held that the Due Process Clause protects against state action only, and as it was Randy DeShaney who abused Joshua, a state actor, the Winnebago County Department of Social Services was not responsible.
Because the father wasn't the government, and laws are only to protect people from the government and not from each other.
Constitutional law for failure to protect Joshua DeShaney from a private actor. Although there are conditions under which the state is
obligated to provide protection against private actors, and failure to do so is a violation of the 14th Amendment. The court reasoned
is obligated to provide protection against private actors, and failure to do so is a violation of 14th Amendment rights, the court reasoned. The
What,
affirmative
the kid
duty
should have
to
just
protect
protected itself
arises not
at
from the
4?
state's knowledge of the individual's predicament or from its expressions of intent to help him, but from the limitation which it has imposed on his freedom to act on his own behalf. It is the state's affirmative act of restraining the individual's freedom to act on his own behalf, through incarceration, institutionalization, or other similar restraint of personal liberty, which is the deprivation of liberty, triggering the protections of the Due Process Clause, not its failure to act to protect his liberty interests against harms inflicted.
The affirmative duty to protect arises not from the state's knowledge of the individual's predicament or from its expression of intent to help him, but from the limitation which it has imposed on his freedoms to act on his own behalf. They're saying that the state had no obligation to intervene in a case of child abuse that nearly murdered the child because the law is that the state has an obligation to protect, not an obligation, but the state's agreement is that, the mother isn't allowed to murder her husband for being a child abuser, or if the child were older and could defend itself, it was a 4-year-old, the child could defend itself. It's saying that's illegal. The mother couldn't kill her husband. The child couldn't fight back and kill the husband or really prevent it. We've removed that right from you, but from the limitation which it has imposed on his freedoms to act on his own behalf. Is the state's affirmative act of restraining the individual freedoms to act on its own behalf through incarceration, which is the deprivation of liberty, triggering the protection of due process, not its failure to act to protect his liberty interests against harms inflicted by other means. The state only has the obligation to imprison, not the obligation to protect. Because their interpretation of the social contract is that the social contract is, I have the right to remove your rights, not the obligation to protect them. What? Huge realizations about the fundamental operation of this country. What the fuck? Civil wrong. The 14th Amendment does not make every tort by a state actor a violation of constitutional rights. Specifically, the act of creating a Department of Social Services to investigate and respond to allegations of child abuse may have meant that the Winnebago County assumed the duty to prevent it, and failure to fulfill that duty may have constituted a personal wronging. Okay, all right, let's read the dissents, and then we're going to learn about poor Joshua Lament. That sounds like it's going to be heavy.
The court's ruling generated 2 dissents. The first, by Justice William Brennan, asserted that whether the Due Process Clause gave Joshua DeShaney a constitutional right to protection against abuse was irrelevant, since it was not an argument presented to either of the lower courts or even to the Supreme Court, and no one, in short, has asked the court to proclaim that, as a general matter, the Constitution safeguards positive
Positive as well as negative liberties.
10. He added that Rehnquist used a flawed interpretation of the Estelle and Youngberg precedents, which Brennan held to stand for the much more generous proposition that, if a state cuts off private sources of aid
then refuses aid itself,
it
cannot wash its hands of the harm.
that results
Heavy.
from its inaction.
Heavy.
11.
Finally, government bodies
Brennan
had
argued
no
that
power or
Wisconsin's
role.
child protection laws created a regime in which private citizens and government bodies other than the Department of Social Services had no power or role to intervene with child abuse other than notifying the
There's a
DSS.
illager thing up there.
As
Okay,
such,
maybe this place is legit. I
Brennan
might be able to do
held that
something
the
with this place.
Child protection laws constituted the same custodial deprivation of liberty that Rehnquist's opinion held necessary for a due process violation. Harry Blackmun, Associate Justice of the Supreme Court of the United States. A second,
Keep
shorter and
feathers.
more famous dissent
Memorable,
was
be
written
useful to
by
me.
Justice Harry Blackmun, who had, along with
He's an
Justice
associate
Thurgood Marshall,
justice.
joined Brennan's dissent. In the first of his opinion's 4 paragraphs, Blackmun reiterated Brennan's contention that there had been state action in
Establishing a DS that promised to provide services.
protection against child abuse and absolved all other state and non-state actors of the responsibility or authority to act. He went on to compare the court's ruling to the Dred Scott case, saying that in both cases the court upheld an injustice by choosing a restrictive interpretation of the Constitution and then denying that choice. Poor Joshua Lament. Edit.
It's famous to its 4th paragraph.
Blackmun's dissent is famous due to its 4th paragraph. Poor Joshua.
Okay, this is going to be heavy, and I'm going to have to read the fuck out of this, so I'm going to give it a sec for my brain to fully interpret what I'm about to read. While playing a little bit of the game for a sec. Okay, get rid of this damn thing. All these items suck. Get rid of them. Okay, cool. Alright, I'm going to read this specifically, like on my own. Or Joshua.
Victim of repeated attacks by an irresponsible, bullying, cowardly, and intemperate father, and abandoned by respondents who placed him in a dangerous predicament and who knew or learned what was going on,
and yet did nothing.
Did essentially nothing except, as the court revealingly observes, ante, at 193, dutifully recorded these incidents in their
They stood by and watched in their files.
It is a sad commentary upon American life and constitutional principles, so full of late of patriotic fervor and proud proclamations about liberty and
justice for all, but not for this child.
Joshua DeShaney now is assigned to live
the R word, but that's what people used back then, but mentally disabled in a terrible way.
Joshua and his mother, as petitioners here, deserve, but now
are denied by this court the opportunity
to have the facts of their case considered in the light of the constitutional protection that 42 U.S.C. Section 1983 is meant to provide. 12. President Bill Clinton quoted the "Poor Joshua" paragraph in his remarks on Blackmun's retirement, and the DeShaney v. Winnebago dissent was, along with his authorship of the Roe versus Wade decision and the first part of his Flood versus Kuhn
weird. I'm not going to keep that item. I don't know how to use it correctly.
Referenced element of Blackmun's career in his obituaries. It was also quoted as the headline for Time magazine's
Harry Blackmun, retirement, dissent was along with his authorship in Roe v. Wade decision in the first part of his Flood versus Kuhn majority opinion, Blackmun's career in his obituary. So he wrote, people hyped up the fact that he responded the way that he did. Okay, well, I believe at this point we are reasonably done looking at any the stream has ads now. No, it doesn't. There's no way the stream actually unironically has ads. How the hell does my stream, how do streams even get ads? Yeah, I got an ad. How's the new chair? Your stream has ads now. Yeah, I got an ad. That's weird. Okay. Well, I'm gonna make a whole 3 cents off of that. The chair's fine. The computer's fucked, and I don't know what's wrong with it. It won't give me the full FPS that it should be for the game, and also I'm still having the issues with the encryption on the storage drive or whatever. It's really annoying. All right, moving on. We are now going to read the case briefs. Like this is like a resource that a lot of law students will tend to use. Law and pre-law students will use. Where they summarize Supreme Court cases. Don't think it's written with AI. Pretty sure. I guess I'll notice. But seems to be like a legit resource that people use to understand these cases quickly from a legal perspective. So we're going to read the higher level, and then we will end by getting to the actual Supreme Court opinion in a little bit. Let's see. Yeah, all the drivers are up to date, and yet it's still acting this way. It doesn't really make any sense, but I'll just have to deal. All right, let's read the summary for Castle Rock versus Gonzales, and then we will read the summary for Descheny versus Winnebago. Actually, let's read Descheny versus Winnebago first, because it seems like it's going to get referenced a lot, and we just finished up reading the wiki, so it'll help me make connections.
Descheny v. Winnebago County. Citation. Descheny versus Winnebago County Depth of Social Services, 489 U.S. 189, 109 S.CT 998, 103
All right, what I would
L.
need next
ed.
is iron to make like
249,
buckets and stuff out of.
57 USLW 4218, U.S. February 22nd.
And frankly, I'd just go get enough iron to build a portal manually.
Brief
That's
fact
probably what I'd do.
summary. The mother of an abused child, Ms. Descheny, petitioner, brought an action pursuant to 42 U.S.C.S. Section 1983 against Winnebago County.
Let's do a loop and see if we can
Department of
find
Social
like an
Services
exposed magma
Department
pool. And if
its
not, we're going to
various
start digging.
employees,
And
respondents, for
it's kind
failing
of hard to
intervene
decide whether or not to.
protect the child from beatings by his father.
It's going to be hard to decide whether or not
The
to.
United States Court of Appeals for the Seventh
I forgot what I was going to
Circuit
say.
affirmed the trial
It's going to be hard to
court's
decide
order
whether or not to
granting
restart.
summary
Like, oh, this
judgment
isn't good
in
enough or
favor
not.
of
But this is the first one that has a
respondents.
village nearby.
Petitioner sought
And it's got an
review.
illager outpost over there, which might have
Synopsis
arrows
of
and
rule of
crossbows.
Nothing in the language of the Due Process Clause of the 14th Amendment requires a state to protect the life, liberty, and property of its citizens against invasion by private actors. Facts.
It's only protection of people by the government, not of each other.
Joshua Descheny went into a coma resulting
So
in
what is the argument going to be? Is the argument going to be, well, individual states should make laws to protect people from each other? What? How is that not just something we agree on universally as a country, damn it? I think anything else is stupid, ridiculous, and like 18th century behavior. Utterly ridiculous.
However, remove Joshua from his father's custody. Ms. Descheny subsequently sued the department. She contended that the department had deprived the child of his liberty interest in bodily integrity, in violation of his rights under the substantive component of the 14th Amendment's Due Process Clause, by failing to intervene to protect him against his father's violence. Issue. Does a state, in failing to protect an individual against private violence,
violate the Due Process Clause of the
violate
14th
Due
Amendment?
Process Clause of the 14th Amendment? Held. No.
No.
The Due Process Clause
Does not impose a special duty in the state to provide services to the public for protection against private actors. Jesus.
Against private actors if the state did not create those harms. The clause is phrased as
steal
a
this guy's
limitation
house.
on the state's power to act, not as a guarantee of certain minimal levels of safety and security, while it forbids the state itself to deprive individuals of life, liberty, and property without due process of law. Its language cannot fairly be read to impose an affirmative obligation on the state to ensure that those interests do not come to harm through other means. Dissent.
Right, I need some wood.
Justice Brennan, joined by Justices Marshall and
There's
Blackmun,
not that wood nearby.
dissented. Brennan focused on the state's knowledge of the individual's predicament and its expressions of intent to help him, i.e., the Department of Human Services' involvement.
And I
in
wish
the
I could have
case
gotten
and
iron
its having
somewhere
learned of
quickly.
the violence inflicted on the child. Brennan essentially equated this to a limitation of his freedom to act on his own behalf. In other words, the involvement of the department effectively precluded non-government
Upgrade here.
entities from intervening, and when the department failed to act on suspicions of child abuse, it became morally culpable
For that harm that ensued.
Discussion.
Okay, let me understand
In
this
its
precedent a
analysis-
little bit harder. Brennan equated this to a limitation of his freedoms to act on his own behalf. The involvement of the department precluded non-government entities from, by making a governmental organization with the responsibility to help this kid, you've taken the responsibility away from pretty much anyone else, which is something you shouldn't be allowed to do unless you are able to do that job well. Which is an interesting line of reasoning that I don't fully understand at this moment, but I'm going to continue attempting to pay attention to as I keep learning about this. Let's do some of this real quick. Let's get myself a basic sword. Get myself a basic pickaxe. And then I'd like more dirt blocks. That's what I will go get. And maybe a couple of chicken. Okay, alright, I'm gonna go get a fuck ton of dirt blocks from this. Okay, discussion. Press.
Analysis. The Supreme Court of the United States determined that the 14th Amendment did not require a state or local governmental agency to protect its citizens from private violence or
So
other
they're really
misacts
saying that we
not
just don't have
attributable to the
any
conduct of its
existing
employees.
law constitutionally that says the government has a
court
responsibility to
draws the
protect people?
distinction between the limits of government action and government responsibility. Although the liberty protected by the Due Process Clause affords protection against unwarranted government interference, it does not confer an entitlement to such governmental aid as may be necessary to realize all the advantages of that freedom. The state's responsibility to protect citizens is one of general scope. If the Due Process Clause does not require a state to provide its citizens with particular protective services, it follows that a state cannot be held liable under the Due Process Clause for injuries that could have been averted had it chosen.
The state's responsibility to protect citizens. Maybe that's a misspell. The state's responsibility to protect citizens is one of general scope. If the Due Process Clause does not require a state to provide its citizens with particular protective services, it follows that a state cannot be held liable under the Due Process Clause for injuries that could have been averted had it chosen to provide them. So it's... What I'm coming to realize is that a lot of these Supreme Court challenges are people being like, hey... It's people kind of pointing out that, like, this document is old as hell and doesn't do anything that it should in the modern day. Basic shit, like requiring the government to protect its people.
Even where such aid may be necessary to secure life, liberty, or property interests of which the government itself may not.
The government can't get rid of it, but the government can't provide it. So, what is this? Okay. All right, that was the summary of Deshania and Winnebago. Now we are back on to Castle Rock. Let's really pay attention to what it's saying here. I am not beating Minecraft before this shit is over. This is only going to be like a 2-hour stream, isn't it?
Obtained a court order requiring her estranged husband to
stay away from her and their 3 daughters.
When her husband took the children without permission, plaintiff contacted the Castle Rock defendant police department several times throughout the night.
Yep, it was sad reading that.
The arrest of her husband in
return of her children.
Defendant's police officers did not take action in response to plaintiff's complaints, and plaintiff sued for violating the Due Process Clause by depriving her of the property right granted by the restraining order without due process.
Property right? It treats the kids as property right? Is that how this works?
Ultimately murdered the 3 children.
Which I'm sure, obviously, like, you know, he got killed. That would have been a court case if he hadn't been killed.
Property interest in its enforcement on the obtaining party for purposes of the Due Process Clause when police enforcement is discretionary. Facts.
What?
Plaintiff sought and received a restraining order against her estranged husband, ordering him to stay away from her and their 3 daughters. The order included language to law enforcement officials dictating that such officials shall use every reasonable means.
A restraining order does not grant a property interest in its enforcement on the obtaining party for the purpose of the due process. I'm gonna need to Google what the hell that's even talking about. No, I don't want the AI briefing. What? How about what is a property interest? No. The rights in property of an individual and entity when it concerns restraining orders. What does that mean, though? No, this is not at all what this seems to be. Restraining order means keeping that person away from your home. Does not grant a property interest in its enforcement. What is a property interest legally? That says AI. I don't want to use AI. I just want someone to actually write this. Property interest refers to legal right that a person or entity has in a property. Ownership. Are children aren't considered are property legally? No way. Same rights to owning. I don't understand what the property interest is. Like, of her home being protected from her husband? I thought the point of restraining order is to protect people. On the obtaining party for purposes of the due process clause. Okay.
Means to enforce this restraining order. Law enforcement was told to arrest the restrained party when it had probable cause to believe
yep, they had probable cause and didn't act.
Violated the restraining order. This language was a restatement of a state law describing law enforcement duties related to the crime of violation of a restraining order. While the restraining order was in effect, plaintiff's husband took their 3 daughters
violated the order, so that
order.
should be probable cause for an arrest, but the cops chose not to.
Contacted the defendant police department and reported
I should have watched a documentary on this when I get a chance. I bet there's a good video documentary on this topic. Nothing they could do?
Were not returned by 10 p.m.
Because Jesus.
Plaintiff's husband called
and then she called at 8:30. Okay.
Tell her he had the children at an amusement park. Plaintiff again notified the police and asked them to arrest her husband. The police officers again told her to call back at 10 p.m. Plaintiff called at 10 p.m. and was told to call again at midnight. Plaintiff called at midnight and was told that an officer was coming to her home.
Yeah, only then?
No officers arrived. So plaintiff went to the police
nobody
station
came.
to file a report at 12.
You call for help and no one comes.
The officer made no efforts on behalf of plaintiff's complaint and instead went to dinner.
What?
At
What?
3:20 a.m.
What? No officer arrived. Plaintiff went to the police station. The officer made no effort on behalf of the complaint and instead went to dinner. The cop that was sent to her didn't come and went to get food instead. Despite the call he had being, my husband took the kids. I don't know where they are.
Plaintiff's husband
arrived
at the police station and opened fire with a semi-automatic handgun he had purchased earlier in the
Jesus H. Christ.
He was shot and killed by responding officers. Police then found the bodies of his 3 deceased daughters in his
and it was their fucking failure to do something extremely basic.
Alleging that she had a property right in the enforcement of the restraining order and that the municipality's failure to enforce the order violated the due process clause when it violated her property right.
So you and then qualified immunity comes in and you're just not allowed to sue when a cop and an entire department fails like this? What?
Restraining orders and tolerating the failure to enforce such orders by its police officers.
That looks interesting. What is
Plaintiff
that?
further alleged that the town's actions were willful, reckless, or grossly negligent.
Ow, ow, ow.
The U.S. Supreme Court granted certiorari.
Oh,
The
you idiots
remainder of
followed
the
me here?
procedural
You're insane.
posture is not included in the casebook excerpt. Issue.
Oh, found a lava pool. We're good. Look at this. I found a lava pool next to a freaking thing of water. It's just over here. Huge. This is a great seed.
Held.
All right, I just need to go get a bunch of iron, which will probably take a while, and then I'm good.
A restraining order does not grant a property interest in its enforcement on the obtaining party for purposes of the Due Process Clause when police enforcement is discretionary.
Police enforcement is discretionary.
Not every government
benefit carries with it a property interest in that benefit. I still don't know what property interest means. I'd love to. I'm just not getting it.
Interest in a benefit. A person must have a legitimate claim of entitlement to it. Claims
of like
entitlement to a benefit
the
from existing rules or independent sources
of saying like the restraining order is your property and you have a right to it being enforced.
Officials have the discretion to either grant or deny the benefit.
What?
In this case, the state statute that laid out.
Let me understand this better. A restraining order does not grant a property interest. I need to keep Googling until I understand it. What is a property interest in constitutional law? Cornell. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of the grand jury accepted. What the fuck? Just say the word property. You shall not be deprived of life, liberty, or property without due process of the law. I still don't know what they mean by property interest, really. A restraining order does not grant a property interest in its enforcement. No, I don't want to see the AI briefing. Stop. No, I don't. That does not make sense. So, I think I'm piecing it together just barely. The restraining order acts as property that a person has obtained through the state. And, like, the restraining order says to follow it. So, she went to the police and said, I have a restraining order. It's my property. And it says that you're going to do these things. Do these things. And then the argument is that, no, we don't have to do it. Even though you have it in your property and it is yours, we actually don't have to enforce it. Why? What is this country? Like, what kind of joke is this place? This is like a joke. Like, this is like a bunch of fascists in a trench coat. This isn't a country. You cannot call that. You can't call that shit civil society. Like, that's not society. So civilized. When your society can't make that basic fucking thing work. Ridiculous. Ridiculous. This is when people talk about like the West and their love for the West and like all the great things the West has achieved through democracy. I'm going to be like, what about this though? That doesn't really seem like that civilized. Like, if anyone's a savage, it's probably the people that allow the existence of a country wherein a person can get a restraining order, but legally, the police have no obligation to actually enforce it. There is no social contract there. You are no better than cavemen. You have failed. You have not created a society. You have failed.
Brief fact
Insane.
summary.
Right, that was the whole thing, was it? No, it just randomly started somewhere wrong. More tools. Read aloud. Thank you.
Scalia, J. No. A restraining order does not grant a property interest in its enforcement on the obtaining party for purposes of the Due Process Clause when police enforcement is discretionary. Not every government
I know, we're rereading that bit, but
carries with it a property interest.
I don't mind rereading if I'm going to learn
benefit.
something.
To have a property interest in a benefit, a person must have a legitimate claim of entitlement to it. Claims of entitlement
It looks like this
to
is
a
a
benefit come from existing
possibly
rules or
possible speed run
independent
at this point.
sources, such as state law,
Quick run,
and do
moderately not
exist
slow
when
run.
officials have the discretion
What I'll
to
call that.
either grant or deny the benefit. In this case, the state statute that laid out law enforcement duties in enforcing restraining orders did not make enforcement mandatory. Enforcement is within police discretion, as is the long-standing
Enforcement is
custom.
completely discretionary.
If the
Like, they're
statute
reinforcing
wanted
that
to make
explicitly. The
enforcement
police do not have a
mandatory,
duty to
it
protect.
would use stronger language than directing the use of every reasonable means to enforce a restraining order, or directing the officers to arrest or seek a warrant. Under this language, a police officer would likely have the discretion to decide that even with probable cause to believe there was a violation, the circumstances weigh against enforcement in a particular instance. The need for such
I have plenty of wood,
discretion
actually.
is apparent in this case, where the location of the restrained party was unknown. The language of the statute requires only that police seek a warrant.
For
Plaintiff
arrest.
does not specify which means of enforcement, arrest or
warrant,
she was entitled to, and this uncertainty weights against finding the duty to be mandatory.
What?
Even if the police were required to arrest, or if impracticable, seek a warrant, the issue is that seeking an arrest warrant is procedural. Procedure alone cannot support a property interest. Even if the statute made enforcement mandatory, plaintiff would still not necessarily have a legitimate claim of entitlement because laws making government action mandatory can serve legitimate purposes other than granting a benefit on a specific class of people. Finally, even if plaintiff had a legitimate entitlement to enforcement of the restraining order, this would not necessarily create a property interest for due process purposes. This entitlement would have no monetary value and would arise incidentally, not out of a government service or benefit, but out of a function that government has always performed, arresting people when probable cause exists
to arrest
believe
them,
they have violated
committed a crime.
the law.
Yep.
Plaintiff does not have a property right protected by the Due Process Clause. Judgment for defendant.
Why are we doing
The
property right
remainder of the disposition
as
is
opposed
not
to life,
included
liberty?
in the casebook excerpt. Dissent. Stevens, J.
Justice John
The
Paul
state
Stevens
here
keeps killing it.
created
He
an
might have been
entitlement
a
to
really good
police
dude.
protection,
The state
which
here
the
created an entitlement to police
Constitution
protection. What's the
allows a
Constitution
state
allows
to
the state
do.
to do? This is all reasonable.
The Court of Appeals held that the state had granted plaintiff an entitlement to mandatory individual protection by the police department, and the majority errs in failing to follow that holding. Even if this court was right not to follow the lower court's decision, it should have certified the question to the state's highest court.
It should have said
Statutes
that police
like
have an
this
obligation
one
to
were
serve and protect.
intended to eliminate police
But no.
discretion in this area and were intended to benefit the narrow class of people who obtain restraining orders. The majority's conclusion that a citizen's interest in the government's commitment to provide enforcement in certain specific circumstances is not a property interest is wrong. A citizen's property interest in a government commitment to enforce such an order is as real and worthy of protection as the citizen's interest in any other important government service.
Property interest. They've gotten
The
a
state
property
statute's
through
use of the
the state.
word "shall" demonstrates that the legislature intended
Oh, we got iron.
enforcement to be mandatory.
Hypothetically, I only need 2
It
buckets to
is
make a thing,
unclear what stronger
but I don't know
indication
how
the
to quickly
majority
do it.
thinks should be used.
I've just seen people do it before.
Under the law, the police are required to provide enforcement of the restraining order and do not have the discretion to ignore violations. The majority focuses instead on
Dude,
what
that should be
type of
enough iron
enforcement
if
is
I'm, like,
required.
kind of understanding.
An entitlement may still exist where the content
I'll just
of
have
that
to really
entitlement
experiment with
varies
understanding how to
depending
make a
on the
lava pool work.
situation. Police enforcement of a restraining order is a government service that is of the same value as other government services. This case should be treated the
This is
same
going to be
as
the
if
4th time I've
plaintiff-
Googled it. I still don't understand what a property interest is. The takings clause of the Fifth Amendment protects property interests from government taking without just compensation. Is a hot dog a sandwich? Let me see. Is a restraining order a piece of property? I really am not following this still. This case should be treated as the same as if they had hired private security to protect her family from her husband. She clearly would have had a property interest in the contract in that scenario, because plaintiff's entitlement is based on a statute and a judicial order instead of a formal contract. Does not provide a rational basis for failing to see it as a protected property right. I'm so confused. Are children property? However, the legal framework surrounding children's rights and is this AI? No, this is from Legal Clarity. Children are considered a part of the family and have constitutional rights that protect their interests. The concept of or parents of the nation is a legal doctrine that grants the state the authority to act as a guardian for minors. Yeah, I'm still not following. I'm really gonna have to like see. Rational basis for failing to see it as a protected property right. Concurrence. So this is someone agreeing with the original ruling. Sauter. It's not Sotomayor. Sauter J. Close read aloud. Start read aloud. Okay. Read aloud. Thank you.
Concurrence. Suitor, J. The Due Process Clause only protects substantive rights. Plaintiff is instead claiming a right
in a state. So it really is treating it like the
Although
property is
process can
the
protect
order.
Substantive rights. The process alone does not create a substantive property
interest.
Finding for plaintiff would blur the line between the property right that is protected and the process created to protect it, and would federalize all mandatory state law procedural direction to law enforcement. Discussion.
No idea what a
This
bottle of Cheney
opinion
is for.
extends the precedent established in DeShaney v. Winnebago County Department of Social Services, 489 U.S.
There's the bucket.
189, 1989.
I got some food. I got some potatoes. That's huge.
In that case, Chief Justice Rehnquist wrote that N. Authing in the language of the Due Process
state to
Clause
protect
itself
life.
requires the state
So
to
amend it.
protect the
Like,
life,
when was the last time we
liberty,
amended anything?
and property of its citizens against invasion by private actors. The clause is phrased as a limitation on the state's power to act, not as a guarantee of certain minimal levels of safety and security.
Okay.
1.
That might be a quote
G's
to work with.
language cannot fairly
That might be a
be
quote super worth working with. The clause is phrased as a limitation on the state's power to act, not as a guarantee of certain minimal levels of safety and security. So again, they're saying the Constitution is written such that it protects you from the government interfering with your life, liberty, and property. But it says nothing of police's obligation as a service that you pay for and make right sacrifices to afford and taxes. The police, however, are not obligated to protect you from other people, only from the government. What? What? This all just reads as insane. As like, this is not society. You are not a fully formed society. You are the very same savages you claim to have been against.
Failure to protect an individual from violence by a private citizen is
genuinely. There's a lot of this bad bias to see and imagine native and indigenous societies as like peaceful and flawless utopias, but like that's not true at all. And in fact, like that is a stereotype within and of itself to assume that because of depictions of it. The reality is that native and indigenous communities had violence, they had wrongs, they had sin, no different than any other community ever, regardless of law. And their even their governmental or social structures. They were not like perfect anarchist societies. They had systems of government that were just not the same as what American exceptionalists tend to summarize their take as the sort of us versus them, they're savages type deal. Simultaneously, however, let's say like that's a discussion a human would even imagine having. That didn't do what I wanted it to do at all. Oh, see, that made one. Yeah, I mean, hey, something's happening here, right? Something is certainly happening here. I mean, something is happening, absolutely. Do I understand what's happening right now? No, not really. How would I do this? A dirt block there. Open up this. Okay. I think that's the minimum, is you need 2 wide and then a certain number tall. So do I do this? I put these next to each other. I hit one with the other. No, that didn't work the way I expected it to. No. Okay, so I'm going to do that. I'm going to hit that and then hit this. Oh, okay. No way. I am a Minecraft speedrunner. Nope, that didn't work. Trying to get burnt. So I need to like build up a dirt framework around it while I do this. A state's failure to protect an individual from violence by a private citizen is not a violation of the Due Process Clause. So they're saying legally it's not a violation of the Due Process Clause, but like let's just talk about like philosophically. You don't think I just ruined my freaking thing of stuff. That's not good. Uh-oh. I about ruined this for me. The whole point is if I fuck this up, I'll need a diamond pickaxe. I really don't want that to happen, so. Okay, keep trying not to fuck this up, preferably. Yeah, let's just not mess this up. The biggest question here is whether or not the founding fathers and the writers of the Constitution intended for a government to exist that would protect a person.
The Supreme Court will not read broad
it would
programs and policies as granting legally enforceable rights. Study assets. Introduction to separation of powers and congressional powers.
Okay, was that actually the end this time?
Castle Rock versus Gonzales.
Yeah, okay, that's the end of that one. We are officially on to the actual Supreme Court opinion document itself, and I am barely building another portal. Wonderful. Okay, I clearly may or may not know how to build this, which is pretty cool. Genuinely wonder where I learned this. Like, I just watched this enough times from other speedrunners that, like, I figured out how it works. I can't remember what the correct height is, so I'm just going to go with this. Okay. I wonder how I'm going to build it up top, though. I really don't know. All right, we are starting this. Let's see, more tools. Honestly, I'm going to play Minecraft for a sec. Try to give myself a chance at pacing this correctly, you know what I mean? Oh, I totally know how to build this. This is huge. I can totally make this happen right now. I can totally build this, right? Oh, I don't know if I'll have enough lava, though, or if I'll mess up before I get too far. Okay, right. It is still this issue of it needs to be to its side for some reason. So I put that there. I put this there. Okay, okay. Things are happening. Indeed, things are indeed happening. Casually building another portal for the first time using this method. Wow. Okay, this is certainly interesting. Okay, it looks like I do not have infinite lava, which is a concern. So lava there, that there. Oh, wow. Okay, very fun. Still not much of an idea of what's going on, but maybe I can do this. Maybe I can do this. So I'm going to build the portal and then I'll start reading. I'm just curious. I want to see if I can kind of get close to getting done or maybe actually get done with the game. 20 pages though, I just don't see that happening. Oh, I totally messed that up. I don't know. It looks like I might exactly run out of lava based on what I'm doing here. If I keep screwing up. Because I do in fact keep screwing up. And then I just need one more and it will connect, technically. And I have like exactly 2 things of lava left. Oh, that's a lava generator right there. So I should be good. Okay, no way. I'm building a freaking nether portal. But then by the time I start reading, like there's no way I'm going to get to a fortress or whatever. The place with the angry on fire things. Forget what those are called. Got it. Okay, okay, let's see. Let's take a look. Do I have a circle type deal thing going on? I feel like maybe this isn't tall enough. Does it have to be 4 tall or 3 tall? Oh, if I messed up, that's going to be so bad. I think I messed up. I think it's supposed to be... Maybe. We'll see. I don't know. I'll need a piece of flint first. I'll have to go find gravel and make a flint and steel real quick. Let's eat up some of these. So I'm going to at least start the portal. Okay, there's a flint. I happen to have a steel on me. Let's see if I messed up the proportions. If I did, I might have to like literally restart. I feel like those are the minimum proportions for this, right? Oh, let's go. The portal has been, I did remember. It actually could be smaller a little bit. I remember now. Okay. All right. Well, we have 20 pages of Supreme Court document to get through that we're reading really slowly, so let's see what happens.
Cite as 545
Wow.
US ___ 2005.
2005.
Opinion of the court. Notice.
All right, this is it. This is the official Supreme Court opinion. It's going to be hard to follow.
Publication in the preliminary print of the United
And as it stands,
States
this has not been
Courts.
overruled since this got published.
Readers are requested to notify the reporter of decisions.
It has not been overturned.
Supreme Court of the United States, Washington, D.C. 20543, of any typographical or other formal errors, in order that corrections may be made before the preliminary print
I won't need
goes to
seeds.
press. 1. Supreme
Let's
Court
just
of
try
the
and take
United
everything we can,
States.
really.
underscore 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 underscore
Yeah, it's gonna do that, and it's gonna
underscore
suck, and we're just gonna
underscore
cope. That's all we got.
underscore 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 underscore.
What a wonderful beat.
Number
Torches are important.
04278.
Diorite's not important. Gravel's not important.
Underscore 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 underscore
That's annoying already.
underscore underscore
Wonderful. I love it.
underscore underscore. Town of Castle Rock, Colorado. Petitioner.
I got potatoes. I got
5,
charcoal. I got
Jessica
coal. I got
Gonzales,
my that.
individually and as next best friend of her deceased minor children.
Next best friend. Next
Rebecca
kin.
Gonzales, Catherine Gonzales, and Leslie Gonzales.
Alright, I've got the
On
basics.
writ
I
of
need to go build a house over
certiorari
there.
to the United States Court of Appeals for the 10th
And I need to
Circuit,
keep feeding
June
carrots to these
27th,
pigs so I have plenty.
2005. Justice Scalia delivered the opinion of the court.
There we go.
We decide in this case whether an individual who has obtained a state law restraining order has
I'll
a
make my own farm
constitutionally
over there.
protected property interest in having the police
Police enforce the restraining order
when they have probable cause to
believe it has been violated.
I. The horrible facts of this case
Case
are
are
contained in the
contained.
complaint that respondent Jessica Gonzales filed in federal
So at least they're trying to
district
act a little human by saying, oh, this is
because the
bad.
case
Because it was a
comes to us
horrible
on
murder.
appeal from a dismissal of the complaint, we assume its allegations are true. See Swierkiewicz vs. Sorima N.A. 534 U.S. 506, 508, N1, 2002. Respondent alleges that petitioner, the town of Castle Rock, Colorado, violated the due
nice.
process
More coal.
clause of the 14th Amendment to the United States Constitution when its police officers, acting pursuant to official policy
The idea
or
that they could read
custom,
this and not
failed
at
to
least be like,
respond
oh, this is clearly begging the question of whether or not police have an obligation to protect
Castle
people, and they
Rock
didn't
v.
just immediately be like, well, yeah, of course they
Gonzales.
do. The fact that they didn't is
Opinion
insane.
of the court. To her repeated reports that her estranged husband was violating the terms of a restraining order. Point 1. The restraining order had been issued by a state trial court several weeks earlier in conjunction with respondent's divorce proceedings. The original form order, issued on May 21, 1999, and served on respondent's husband on
The original
June
form
4,
order.
1999, commanded him not to
Molest or disturb the peace of the children.
respondent or of any child, and to remain at least 100 yards from the family home
Home
at all times.
Outside of designated meeting periods and
366
places.
F, 3D 1093, 1143,
Wait, like,
CA
I don't know.
10 2004,
With how common child abuse is in
NBank,
America,
Appendix to dissenting opinion
hundreds
of
and hundreds and
O'Brien,
thousands, hundreds
J.
of thousands of these cases have probably
The
taken
bottom
place
of
since,
the pre-printed
like, the,
form noted that the reverse side
just the
contained
1900s
important
alone.
notices for restrained
And we still
parties
haven't figured out that the police have an obligation to
and
enforce a
law
fucking
enforcement
restraining order?
officials.
How?
Ibid, emphasis deleted. The pre-printed text on the back of the form included the following warning. A knowing violation of
It's
a
a crime.
restraining order is a crime.
Yes.
A
Contempt of court.
violation will
You may
also
be arrested, not
constitute
will.
contempt of court. You may be arrested without notice if a law enforcement officer has probable cause to believe that you have knowingly violated this order. ID at 1144. The pre-printed text on the back of the form also included a
Notice to law
to
enforcement
law
officials.
enforcement officials, which read in part. One petitioner claims that respondent's complaint did not allege that she ever notified the police of her contempt.
Jesus Christ, there's a creeper right there, and I really do not want to play right now. Be gone. Yeah, I'm fine with that. Just blow up. Who cares? Doesn't bother me that much. All right, let's build a house real quick. I'm gonna build a nice waterside house real quick. Yes, probably enough room. Probably don't need any more than that. I'm sure there are kids who have played Minecraft so much that they can like automatically build a base with like 10 blocks. Like a completely competent one that does everything it needs to. I am not such a person. Wonderful. Completely adequate. Yeah. Cool. That seems fine. Did I accidentally make it even? I did. That's awesome. That works. Let's throw a couple of torches down real quick. One there, one there. That works. One here, one here. Wonderful. All right. Bedtime. Bed. And... Jess? How did they fuck that up? How do you even fuck that up? Jess, there we go. Okay. And then furnace, which I will probably make several furnaces per usual. Now my main issue is having wood. I need wood to build the frickin' door. And there are no trees within sight at all. Nearest tree is all the way over there. Let's keep reading. But so this is interesting. The pre-printed text on the back of the form also included a notice to law enforcement officials, which reads in part:
contention that her husband.
I didn't do anything. Why'd you stop reading?
Included the following
Okay,
warning.
sure.
A knowing violation of a restraining order is a crime. A violation will also constitute contempt of court. You may be arrested without notice if a law enforcement officer has probable cause to believe that you have knowingly violated this order. ID at 1144. The pre-printed text on the back of the form also included a notice to law enforcement officials, which read in part: one petitioner claims that respondent's complaint did not allege that she ever notified the police of her contention that her husband was actually in violation of the restraining order. Brief for
Huh? They're alleging that my husband has stolen my children. And they were just like, okay. And they ignored it and never asked, like, why is a happily married woman concerned about her husband having her kids? And she's like, well, they have a restraining order. He's abusive. You fuckers don't know this case? What? Are they really going to make that argument? Like, oh, we didn't really know, though. Like, yeah, you did. You're the people that helped build the fucking case. The people at your precinct knew. Even if you didn't get trained, someone says, someone took my kids, you ask 2 investigative questions and be like, okay, why, why are you calling the police for that? Oh, because it's illegal. You kidnapped them. How is it kidnapping? He's your husband. I have a restraining order. Oh, okay. 5-sentence conversation? Like, what? There's no way that they're really going to try to unironically allege that, like, well, you didn't use legal language to tell us that he was in violation of court. So how are we supposed to know? Oh, go fuck off. That's a level of incompetence that's unacceptable.
7N2. The complaint does allege, however, that
so the police of the order
the police
and requested that it be enforced.
Temporary restraining order, TRO, and
it's reasonably implied the order was being violated. Yeah, it does reasonably imply that. There's no way she didn't do that.
At this stage in the litigation, we may assume that this reasonably implied the order was being violated. See Steel Company v. Citizens for Better Environment, 523 U.
Potato.
S. 83,
Turn it into a baked potato, please.
104, 1998. Cite as 545 U. S. ______, 2005. Opinion of the Court. 3. You shall use every reasonable means to enforce this restraining order. You shall arrest
Is this more
or you shall
is this more direct quote? Which read in part? Oh, I'm not reading the order. This is a footnote. I'm just stupid. All right, let's read the rest of this. So, notice law enforcement officials, which reads in part, you shall use every reasonable means to enforce this.
Shall use every reasonable means to enforce this restraining order. You shall arrest, or, if an arrest would be impractical under the circumstances,
Seek a warrant
for the arrest of the restrained person when you have information amounting to probable cause that the restrained person has violated or attempted to violate any provision of this order and the restrained person has been properly served with a copy of this order or has received actual notice of the existence of this order. Ibid. On June 4, 1999, the state trial court modified the terms of the restraining order and made it permanent. The modified order gave respondent's husband the right to spend time with his 3 daughters, ages 10, 9, and 7, on alternate weekends, for 2 weeks during the summer, and visit, upon reasonable notice, for a midweek dinner. Arranged by the parties, the modified
Jesus
order
Christ.
also allowed him to visit the home to collect the children for such parenting time.
Parenting time.
ID at 1097, majority opinion. According to the complaint, at about 5 or 5:30 p.m. on Tuesday, June 22, 1999, respondent's husband took the
Can't
3
remember the correct
daughters
length,
while they were
but I'll
playing
figure it out.
outside the family home.
1, 2,
No
3,
advance
4, 5,
arrangements had
6,
been made
7,
for him to
8,
see the
9,
daughters
10,
that evening.
11, 12, 13,
When respondent noticed the
14,
children were missing,
15.
she suspected her husband had taken them.
But that's reasonable
At
suspicion.
about
Yeah.
7:30 p.m., she called the Castle Rock Police Department, which dispatched 2 officers. The complaint continues. When the officers arrived, she showed them a copy of the TRO and requested that it be enforced and the 3 children be returned to her immediately.
Yeah.
The officers stated that for Castle Rock v. Gonzales,
The officer stated what?
opinion of
There was
the
nothing they
court.
could do about the TRO?
There was nothing they could do about the TRO and
Huh?
suggested that respondent call the police department again.
Yeah,
if
call
the
us when they're
3
dead,
children
right?
did not return
Just
home
call
by
us when the
10
kids are dead.
p.m.
We have no obligation to actually protect you.
126A.2. At approximately 8:30 p.m.,
Fuck.
respondent talked to her husband on his cellular telephone.
Okay.
He told her he had the 3 children at an amusement
He still
park
kidnapped
in
them
Denver.
and violated the
Ibid.
warranty. The amusement park, by the way, is
Called the
likely
police again and
Elitch's
asked
Gardens,
them
where
to
I go
have
to all the
someone
time.
check for her husband or his vehicle at the
What the
amusement
fuck?
park and put out an all points bulletin for her husband, but the officer with whom she spoke refused to do so, again telling her to wait until 10
What?
p.m. and see if her husband returned the girls.
So fuck you, we don't want to do our job.
126A, 127A.
You know, let's see if he gets violent. Because after nighttime, clearly he's not returning them, and it's kidnapping. But it's already kidnapping.
Her children were still missing, but she was now told to wait until midnight. She called at
Well,
midnight and told
they're
the
just pushing her off
dispatcher
more and more.
children were still missing. She went to her husband's apartment and, finding nobody there, called the police at 12:10 a.m.
Holy shit, she's doing everything a good mom could possibly do.
When none came, she went to
Like,
the
yeah, I'm gonna check where the fuck my kids are.
12:50 a.m. and submitted an incident report. The officer who took the report made no reasonable effort to enforce the TRO or locate the 3 children.
Or locate the kids. Okay, tell me how all of these cops didn't end up in prison for eternity. Genuinely, if you believe in this whole prison bullshit, how the fuck are these guys not in it?
Respondent's husband arrived at the police station and opened fire
with
a semi-automatic handgun he had purchased earlier
Huh?
that evening.
Instead, he went to dinner. At approximately 3:20 a.m., the response arrived at the police station, opened fire. So, like, she genuinely knew something was going to happen. Maybe she called him and was like, "Give the kids back," and he lied. He probably lied about the amusement park thing. I definitely need to watch a documentary on the full like forensic analysis of what actually happened here. Once they got cell phone data, once they corroborated data, you know, passes and shit. What? Like, oh, were they actually at the amusement park? Well, okay, well then the amusement park would have a roster showing that they attended that day. I've got to know the full context, because it just makes it even worse that, like, this mom probably knew. Hey, moms aren't stupid. There are bad moms out there, but, like, the type that would fight this fight to assure her children's well-being probably knew that, like, something was up. Like, something, I'm sure there was a fight on the phone or something too. They're like, there was probably something that triggered the dad to go this far. But, like, the kids shouldn't have been with him in the first place. And in fact, that is the entire point of the protection in the first place. Jesus Christ. I just don't know how you can have this sort of thing happen and then have your highest political officials rule that it was okay and then be like, yeah, developed society. You're not a developed society. You're a joke. That's not a community. That's a joke. Like, you're nothing. Jesus Christ. I just don't know how people get off thinking that the US has a right to be high and mighty when this is our, like, level. This is where we're at. I don't know. I don't know. It's likely that people who fanboy over this country too hard, nationalists, patriots, neither of which I believe in or support their positions. I love when people are like, patriotism is about your community. I'm like, no. We know in practice that patriotism colloquially is used to describe nationalism for the United States, that someone may or may not find agreeable on some basis. Still don't support patriotism. How could you, after knowing your country's history? Disgusting. All of this. How are these Supreme Court justices allowed to get by? How are these cops allowed to get by? Like, I don't understand.
To the police station at 12:50 a.m. and submitted an incident report. The officer who took the report made no reasonable effort to enforce the TRO or locate the 3 children. Instead, he went to dinner.
Jesus Christ.
ID at 1:27 At approximately 3:20 a.m., respondent's husband arrived at the police station and opened fire with a semi-automatic
Skeleton, if you
handgun
played this
he had
game,
purchased
I will
earlier
turn
that
you into
evening.
bone meal and use you to grow my
Police
crops.
shot back, killing him. Inside the cab of his pickup truck, they found the bodies of all 3
Of all 3 of
daughters,
his children.
whom he had already
Murdered.
Ibid. On the basis of the foregoing factual allegations, re. 2. It is unclear from the complaint, but immaterial to our decision, whether respondent showed the police
Not my house!
only the original TRO
You bastard,
or
I'll kill
also
all
the
of you.
permanent, modified restraining order that had superseded it on June 4th. Cite as 545 U.S.
I'm turning all of you into
_
food
2005.
for this. for what you have done.
Opinion of the court.
Talking about Minecraft right now.
5. Spondent brought an action under Reverend Stat Section 1979, 42 U.S.C. Section 1983, claiming that the town violated the Due Process Clause because its police department had an official policy or custom of failing to respond properly to complaints of restraining order violations and tolerate d. the non-enforcement of restraining orders by its police officers. App. To Pet for Cert 129A.3. The complaint also alleged that the town's actions were taken either willfully, recklessly, or with such gross negligence as to indicate wanton disregard and deliberate indifference to respondent's civil rights. Ibid. Before answering the complaint, the defendants filed a motion to dismiss under Federal Rule of Civil Procedure 12(b)(6). The district court granted the motion, concluding that, whether construed as making a substantive due process or procedural due process claim, respondent's complaint failed to state a claim upon which relief could be granted.
So there's just like, yeah, we can enable child abuse and that police aren't obligated to protect you because you didn't use language that we liked. What? Like at some point, dystopia becomes more savage than the very communities and cultures that supremacists and white Western exceptionalists stand for. At some point, your dystopia becomes worse than chaos. And I'm not talking anarchy. Anarchy can be super well organized. I'm talking just chaos. Just like medieval, truly early human organization chaos. At some point, you are worse than chaos because you have structured violence. At some point, chaos looks better than what it is you stand for. And have constructed through the organization of your government and state. I just don't know. I just don't know how to feel. It's all gross. All this is gross. I hate reading this. This is horrible. The idea that they wouldn't say that police have an obligation to protect you is stupid.
2002, on rehearing en banc, a divided court reached the same disposition, concluding that respondent had a protected property interest in the enforcement of the terms of her restraining order and that the town had deprived her of due process.
I need to make a bow so I can start collecting arrows as I fight.
Seriously entertained her request to enforce
see it? I see it.
Protect her
and this time it avoided my house. Very good. Is that an Enderman? If I just saw an Enderman, I'll have to kill it ASAP. I need to start looking out for Enderman too.
We granted certiorari. 543U.
Hey, that's good. I need string. Sticks and string will make a bow.
2004.
I think I need 3 string.
Police officers were also named as defendants in the com.
Okay, let me pause. We are now talking about more important stuff of another section that matters. I've completely given up on my old rules of like, you cannot pause, you have to deal with reading. No, like I'm here to learn. So, my rules, my goals, my stream. Play a little bit of dumb Minecraft while also learning stuff that's important. Hey, leave me alone. Leave me alone, bow boy. Perish. Nice, barely caught that. I have 1 heart. That's gonna hurt. Ooh. More arrows, very good. I do not have enough health for this. I'm going back to the house and hiding. I need to build some armor, huh? Like I need to get some gold. I need to get some iron. Because I'm getting completely beaten up right now. Yeah, okay, fighting is not worth it right now. Okay. Before answering the complaint, the defendant filed a motion to dismiss under Federal Rule of Civil Procedure. So it was dismissed, brought back, dismissed again by the Supreme Court. An understandable procedural due process claim even if it wasn't a substantive violation of due process. Back to reading aloud.
Dent had alleged a cognizable procedural due process claim.
Gotta build a bow.
307F, 3D 1258, CA 10 2002.
Uh-oh, I didn't get enough string.
On
What?
rehearing en
How? I killed like
banc,
10
a divided
spiders.
court reached the same disposition, concluding that respondent had a protected property interest in the enforcement of the terms of her restraining order and that the
What happened
town
to all
had
the different
deprived
spiders
her
from
of due
before? This is
process
stupid.
because the police never heard nor seriously entertained her request to enforce and protect her interests in the restraining order.
Okay, keep reading this. On rehearsing en banc, a divided court reached the same disposition, concluding that the respondent had a protected property interest in the enforcement of the terms of her restraining order. Protected property interest. The order is property? Like, what am I not getting in that still? And that the town had deprived her of due process because the police had never heard nor seriously entertained her request to enforce or protect her interests in the restraining order. I have to imagine that somehow the children are acting like property in a way. Okay.
366F, 3D, at 11:01, 11:17. We granted certiorari. 543 U.S. ____ 2004. 33 police officers were also named as defendants in the
33?
complaint,
Oh.
but the Court of Appeals concluded that they were entitled to qualified immunity. 366
Insane.
F,
Insane.
3D
Completely
1093,
incomprehensibly insane.
CA 10
Fuck you, we have qualified immunity. We
2004,
can do what we want. Are you
en
kidding?
banc. Respondent did not file a
Psycho.
cross-petition challenging that aspect of the judgment.
Okay, they could have maybe resisted qualified
6
immunity, but
Castle
they're
Rock
just
v.
going to lose.
Gonzales. Opinion of the court.
All right, let's go.
2. The 14th Amendment to the United States Constitution provides that a state shall not deprive any person of life, liberty, or
I'm going to be
property
real.
without due process of law.
I'm just going to go get myself killed like 10
And
times and see if I can find it.
14, Section 1. In 42 U.S.C. Section 1983, Congress has created a federal cause of action for the deprivation of any rights, privileges, or immunities secured by the Constitution and laws. Respondent claims the benefit of this provision on the ground that she had a property interest in police enforcement of the restraining order against her husband, and that the town deprived her of this property without due process by having a policy that tolerated non-enforcement of restraining orders. As the Court of Appeals recognized, we left a similar question unanswered in DeShaney v. Winnebago County Department of Social Services, 489 U.S. 189, 1989, another case with undeniably tragic facts. Local child protection officials had failed to protect a young boy from beatings by his father that left him severely brain damaged. ID, at 191-193. We held that the so-called substantive component of the Due Process Clause
One
does
sec,
not
I am
require
checking some real life stuff real quick. Oh, okay, yeah. No, that makes no sense, but whatever. Okay. Minecraft music is kind of going hard right now. I'm enjoying it. Alright, that is when I work tomorrow. I'm checking my work schedule. Okay, I'm good. I've done the checking. Back to reading.
State to protect the life, liberty.
Yeah, I'm just gonna put everything back and I'm just gonna go and die like 10
against
times real quick,
actors.
one after the other.
ID at 195.
Because maybe I can find something by just running around.
However, that the petitioner had not properly.
And I need to get rid of my levels, otherwise I'll start wanting to preserve them and I'll stop wanting to die as often, but dying is completely allowed, I'm pretty sure.
Child protection statutes gave him an entitlement to receive protective services in accordance with the terms of the
We know, however, that the petitioner had not properly preserved the argument that, and we thus declined to consider whether state child protection statutes gave him an entitlement to receive protective services in accordance with the term of the statute, an entitlement which would enjoy due process protection. Why do they keep using him, by the way? Is that their gender-neutral word?
An entitlement which
what do they think they are?
Due process protection. ID at 195 N2.
Right, if I gather enough mushrooms, I can make a mushroom stew or something, I'm pretty sure.
Everything that might be described as a benefit. To have a property interest in a benefit, a person clearly must have more than an abstract need or desire and more than a unilateral expectation of it. He must, instead, have a legitimate claim of entitlement to it. Board of Regents of State Colleges versus Roth, 408 U.S. Cite as
is this wood?
545 U.S. ______.
10 underscores, love that. Huge. Very useful.
Opinion of the court. 7.
Oh, you dumbass.
564, 577, 1972. Such entitlements are, of course, not created by the Constitution. Rather, they are created and their dimensions are defined by existing rules or understandings that stem from an independent source such as state law. Paul versus Davis, 424.
What? No way.
693.
No way. I spawned. What is this? A good spawn for the game or something?
76. Quote.
What? Why is this so much easier than the first time I played?
Supra at 577. See also Phillips versus Washington.
This is bullshit. This used to be so fucking hard.
S 156.
What?
164.
Right.
1998.
Man, if I were good at Minecraft, I probably could beat it in this run.
Our cases recognize that a benefit is not a protected entitlement if government officials may grant or deny it.
Okay, why can't I get in though? What's going on? How do I get in?
Kentucky Department of Corrections versus Thompson, 490 U.S. 454, 462, 463, 1989.
Let me in.
The Court of Appeals in this case.
Oh, but what if it's a fortress? I've heard that it can happen. It's a fortress that doesn't have blazes. What if that happens, huh? Am I just screwed?
The court issued restraining order, specifically dictated that its terms must be enforced and a state statute command, ed. Enforcement of the order when certain objective conditions were met.
Oh my god,
Probable
let me in.
cause to believe that
Where's
the
the
order
entrance?
had been violated and that the object of the order had received notice of its existence.
Why were some of my previous playthroughs so bad in comparison when this random seed is like
at 11:01
10 times better? Like, what bullshit is that?
Also ID.
Oh fuck, I have no idea where I'm going. I don't have a good way to indicate where I'm going either.
At 11:04, 11:05.
Hey, armor. I'll take it. That's huge.
Respondent
Well, I guess I can use this to
that
put
we
my
are
things away before I
obliged
die.
to give deference to the 10th Circuit's analysis of Colorado law on
That seems like it's going
Whether
nowhere.
she had an entitlement to
I'm
enforcement
already
of the
lost.
restraining order. TR of
Why is it so dark in here?
52. We will not, of course, defer to the 10th Circuit on the ultimate issue.
Okay, that's not good.
Whether what
It doesn't
Colorado
seem very
law
big.
has given respondent constitutes a property interest for purposes of the 14th Amendment.
Oh, but down there is something.
That
Clearly.
determination, despite its state law underpinnings, is ultimately one of federal constitutional law.
Oh, here we go. Oh, this is huge.
Although the
I need this to make that one potion, right?
interest is created by
Yeah.
an independent source such as state law, federal constitutional law.
Oh, and I hear
determines
them.
whether the
No
interest
way. And I have an
rises to the
enchanting
level
table.
of a
I
legitimate
just don't remember
claim
what
of
I need to make
entitlement
this. I need
protected by
glass,
the Due
bottles of water,
Process Clause.
and
Memphis.
nether wart. Oh, and I need blaze.
Castle Rock v. Gonzales.
So if I can get a couple of blazes, I can make
Opinion of the court.
What? This is huge.
Light, gas, and water.
I'm taking all this
Craft,
with me already. I'm not gonna wait.
436 U.S.
It's gonna be my
1,
memorizer.
9,
A couple of these blocks.
1978. Emphasis added.
You are
Quoting
kidding me.
Roth, Supra at 577.
Issue. These guys are right here and they're gonna
United States
murder me.
XREL. TVA v. Policy 319 S 266
Uh-oh.
279 19.
Okay, I made a mistake. I'm gonna put everything into a chest and try and find this place again in a second.
Begins, however, with a determination of what it is that state law provides. In the context of the present case,
I'm gonna have to
central state
come
law
with gear.
question is whether Colorado law gave respondent a right to police enforcement of the restraining order. It is on this point that respondent.
Okay. In the context of the present case, the central state law question. I'm gonna have to reread that. In the context of the present case, the central state law question is whether Colorado law gave the respondent a right to police enforcement of the restraining order. It is on this point that respondent's call for deference to the 10th Circuit is relevant. Okay, so they're acknowledging that they might have a relevant point. What are they going to do with that acknowledgement?
Respondent's call for deference to the 10th Circuit is relevant. We have said that a presumption of deference is given the views of a federal court as to the law of a state within its jurisdiction. Phillips.
That doesn't look familiar.
At 167.
Oh, I went this way, didn't I? I remember, I think.
Tie-in can be overcome, however. See Levitt versus Jane L.
Oh, I'm totally cooked. I have no idea where that place is anymore.
S. 137, 145, 1996, per curiam, and we think deference inappropriate here. The 10th Circuit's opinion, which reversed the Colorado District Judge, did not draw upon a deep well of state-specific expertise.
Okay. No, I have refound the pathway.
Language from the restraining order, the
boom, that's it. All right, I just need to figure out a way to make this pathway obvious to myself moving forward.
C 366F 3D at 1103-1109. These texts, moreover, say nothing distinctive to Colorado, but use mandatory language that, as we shall discuss, appears in many state and federal statutes. As for case law, the only state law cases about restraining orders that the Court of Appeals relied upon were decisions of federal district courts in Ohio and
beginning to understand the
Pennsylvania and
pathway.
state courts in New Jersey, Oregon, and Tennessee. ID at 1104-1105.
That doesn't really tell me much. Okay.
N9 1109.4. Moreover, if we were. For most of the Colorado law cases,
Am I memorizing this pathway right now? I am. Very good. I have memorized the pathway. Very good.
Notes declaring them to be irrelevant because they involved only substantive due process.
Slight issue. That guy's going to get me. Like right now, he's going to get me. Then I am not going to survive.
1100-1101 NN. For 5, only statutes without restraining orders, ID at 1101 N5, or Colorado's
No,
Government
I'm going to die
Immunity
before I get
Act,
this.
which the Court
Yep.
of Appeals
There we go, dead.
concluded applies
Alright, I'm gonna have to show up with gear.
State Tort Law Claims ID at
One of these, some food.
N12.
Brewing stand's already ready,
Our
which is nice.
analysis is likewise unaffected by the Immunity
Just gonna have to
Act or
remember
by the
half of this
way that
process.
Colorado has dealt with substantive
Bottle of
due
enchanting.
process or cases. Cite as 545 U.S. ______ 2005. Opinion of the Court. 9. Simply to accept the Court of Appeals' conclusion, we would necessarily have to decide conclusively a federal constitutional question, i.e., whether such an entitlement constituted property under the Due Process Clause and, if so, whether petitioner's customs or policies provided too little process to protect it. We proceed, then, to our own analysis of whether Colorado law gave respondent a right to enforcement of the restraining order. Point 5.
A right to enforcement? What is the point of restraining orders? If the point isn't for them to be enforced.
The restraining order came not from any part of the order itself, which was signed by the state court trial judge and directed to the restrained party, respondent's husband, but from the pre-printed notice to law enforcement personnel that appeared on the back of the order. See Supra, at 2.3. That notice effectively restated the statutory provision describing peace officers' duties related to the crime of violation of a restraining order. At the time of the conduct at issue in this case, that provision read as follows. A. Whenever a restraining order is issued, the protected person shall be provided with a copy of such order. A peace officer shall use
every reasonable means to enforce a restraining order. They failed to enforce it. She said that's not ethical.
A peace
what is the issue?
officer shall arrest, or, if an arrest would be
Uh-oh, we're dropping
impractical
frames in
under
the stream. That's not good.
circumstances, seek
I've seen it do this before.
that do not involve restraining orders. 5 inches something of an anyone but us approach, the descent simultane.
Okay, in order to not lose too much, I'm going to pause it for a bit and see while the stream recovers or not. Just in hopes that it may recover. It's still acting fucky. Okay, we'll have to see how that goes then. Alright, I have these items right now. I can use dirt blocks to defend myself. Okay. This just feels like such bullshit compared to how it was before. What I played last time, but again, I didn't settle on a seed that I thought would be particularly worthwhile. Okay, how does this work? Okay, it's gonna go this way. Stream seems to have recovered. I don't know what's going to happen next though. I'm gonna give it a few more minutes. Then see if the stream is going to 100% recover or not. Oh yeah, I guess I had a couple of items over here a second ago, didn't I? Okay, the first and important thing for me is to get all of these items while I actively burn to death. Okay, I need to go establish a nether wart farm ASAP in the other part of the world. I'm going to do this all one step at a time, so I don't ruin this entire run for myself. I don't think I'll have ever played Minecraft this quickly in my life. Okay, I think no, the stream is not recovered. It's fucked up again, so I really don't know what the issue is or how much it's going to be dropping.
And thus
I guess I'll notice when it totally turns off.
Not only that this court
Hopefully it doesn't, but it totally might.
To the Colorado Supreme Court, post at 5-7, opinion of Stevens, J. But
Stevens,
also
J.
that it should defer to the
10th
Circuit,
Sand.
which itself did not certify any such question, post at 34. No party in this case has requested certification, even as an alternative disposition. CTR of Oral Arg 56, Petitioner's Counsel Disfavor, ING, Certification, ID.
Is that the
At
first time I'm planting a seed? That's not true.
2526, Counsel for
I've
the
been planting
United
seeds for a while.
States
I guess
arguing against
I only planted
certification.
carrots, which aren't a seed, I guess.
At oral argument, in fact, Respondent S. Counsel declined Justice Stevens' invitation to request it. ID.
Contends not only that this court should certify a question to the Colorado Supreme Court, but did the Colorado Supreme Court do anything? To the normal Supreme Court case, but like, what happened after this Supreme Court? You know what? After we're done reading the document, we're gonna try to read about what came after. Maybe I'll try and find an open source video talking about it, which we will watch and I will attempt to learn from. Okay, what's going on now? So I have. Let's go back to the opinion.
ID at 53. 10.
What have I got on me? What do I need?
Castle Rock v. Gonzales.
Some random items here.
Opinion of the court.
Got a sword.
Warrant for the arrest of a restrained person.
Got a
when the
pickaxe.
peace officer
Got
has
torches.
information amounting
Got
to
bread.
probable
And a baked
cause
potato.
that
I would
1.
like a
The
bunch of
restrained
cobblestone
person has violated or
to
attempted
build
violate
around
any
the
provision of a restraining order. And
fire spitting things.
2. The restrained person has been properly served with a copy of the restraining order, or the restrained person has received actual notice of the existence and substance of such order. C. In making the probable cause determination described in paragraph B of this subsection 3, a peace officer shall assume that the information received from the registry is accurate. A peace officer shall enforce a valid restraining order whether or not there is a record of the restraining order in the registry. Colorado Reverend Stat Section 186803.5.
I'm so bothered
3.
realizing that when I did
Lexus
the Project 2025 stream, it took me
emphases added.
24 hours
The Court of
collectively to
Appeals
beat
concluded
Minecraft
that
when
the
like I am
statutory provision, especially
60% of the way
taken in
done
conjunction
in 2
with a
hours right now,
statement
or
from
3.
its legislative
That just bothers
history,
me.
6,
Bad.
and with another statute
If I had
restricting
just kept
criminal and
respawning
civil
things, I could have beat it
liability
quickly.
for
Kept
officers making
remaking
arrests, 7, established the Colorado
worlds,
legislature's clear.
generating worlds, seeds.
6. The Court of Appeals quoted one lawmaker's description of how the bill would really attack the domestic violence problems.
Court of Appeals concluded that the statutory provision, especially taken in conjunction with a statement from its legislative history and with other statute restricting criminal and civil liability for officers making arrests, established the Colorado legislature's clear intent to alter the fact that the police were not enforcing domestic abuse restraining orders. Yes, and thus its intent that the recipient of a domestic abuse restraining order have an entitlement to its enforcement. Yes, they should. And any other result, it said, would render domestic abuse restraining orders utterly valueless. Correct. Sheer hyperbole. Shut the fuck up. It was not sheer hyperbole at all. Like, police can still not protect people to this day.
To alter the fact that the police were not enforcing domestic abuse retraining orders, and thus its intent that the recipient of a domestic abuse restraining order have an entitlement to its enforcement.
Yes, they should. Holy shit. How hard is that to comprehend?
366F 3D at
Uh-oh.
11:08.
One of you fuckers is up here.
Any other result, it said, would render domestic abuse restraining orders.
Okay, slight issue. I never really figured out a way up there, did I?
ID at 11:09. This last statement is sheer hyperbole. Whether or
Ow.
not respondent had a right to enforce the restraining order,
Fuck you.
it
You
rendered
suck.
certain
Get away.
otherwise lawful conduct by her husband both
Stop.
criminal and in contempt of court. See sections 186803.5, 2a, 7. The creation of grounds on which he could be arrested, criminally prosecuted, and held in
Ow.
contempt was
Ow, you're
hardly
kidding me. There's like a
valueless
skeleton
even if
dude
the
coming next.
prospect of those sanctions ultimately failed to prevent him from committing 3 murders and a suicide. We do not believe that these provisions of Colorado law truly made enforcement of restraining orders mandatory. A well-established tradition of police discretion has long coexisted with apparently mandatory arrest statutes. In each
I need to
and
think
every
harder right
state
now.
there
Think
are
harder.
long-standing statutes that, by their terms, seem to preclude non-enforcement by the police.
Did I dodge him?
However, for a number of reasons,
Where is it?
including their legislative history, insufficient
Where's
resources,
that dumbass skeleton at?
and sheer
There it
physical
is. Come on. Come here,
impossibility,
skeleton.
it has been
Come on.
recognized that such statutes cannot be
Come on.
interpreted literally. Hey clearly do not mean that a police officer may not lawfully decline to make an arrest. As to third parties in these states, the full enforcement statutes simply have no effect,
Wait.
and their significance is further diminished.
You did not just say what I think you just said. In each and every state, there are long-standing statutes that, by their terms, seem to preclude non-enforcement by the police. However, for a number of reasons, including their legislative history, insufficient resources, and sheer physical impossibility, it has been recognized that such statutes cannot be interpreted literally. You're saying that because we don't give the police $1 million, billion, trillion, which we already give them $100 million, billion right now, not literally, but hundreds of billions across this country go to policing. But because that can't be $100 trillion, we can't legally, we can't literally interpret the idea that a police officer has an obligation to do their job. They clearly do not mean that a police officer may not lawfully decline to make an arrest. As for third parties in these states, the full enforcement statutes simply have no effect. There should be no such thing as lawfully declining to make an arrest if evidence is obvious that something is happening. Unless he acted in bad faith. Of the Colorado Supreme Court. Okay, well, those police officers should have been. Well, I wonder what happened to those police officers. That is what we will look at after this. What happened to those cops? Anything? Likely nothing? Alright, I need to lock in for the game part for a sec, so I'm going to lock in on the game part for a sec. That fucker is still up there, but this time I'm coming for him. Parrish. You get the fuck out of the way. Oh, look, another one. Nice try, idiot. Okay, I got a blaze rod. And with that, I can go ahead and make fire resistance potions. This is huge. I cannot believe any of this. I don't even know what to think. Like, if I had just kept remaking worlds when I first played, but the point of the first play, though, was like, whatever I get is what I get. And it just so happened to be pretty much exactly hard enough that it took the whole length of the document I was reading at the time. Still, though, it does not escape me how insane this is. Let's see. Okay, make blaze powder. So I think I need water bottles, and for that I'm gonna need sugar cane. Right? No, I need sand. I need to cook sand. Don't know why I thought I needed sugar cane. Give me sand. Ah, yes, sand. There we go. Okay, I still cannot believe how much progress we're making. Okay, more tools. Read aloud.
12.
It's just hard to pay attention, though. It really is when
Castle
I'm trying to
Rock
play.
v. Gonzales. Opinion of the court. The deep-rooted nature of law enforcement discretion, even in the presence of seemingly mandatory legislative commands, is illustrated by Chicago versus Morales, 527
Morales, huh?
U.S. 41, 1999, which involved an ordinance that said a police officer shall order persons to
Chicago versus Morales, 1999, which involved an ordinance that said a police officer shall order persons to disperse in certain circumstances. Yeah, that's what they're using to stop protests.
in certain circumstances, ID at 47 N2. This court rejected out of hand the possibility that the mandatory language of the ordinance afford the police no discretion. ID at 62 N32. It is, the court proclaimed, simply common sense that all police officers must use some discretion.
No, yes, I agree. Let's see. Hey, just watched your counterculture video. I'm a musician and was thinking about joining the rebellion after watching lately. Choice of being fairly uninformed with what's happening. Watching lately, I've made the choice of being fairly uninformed with what's happening because it can feel like a lot, but I might get back into the knowing just for the sake of preserving some of it through music. It's honestly, it's like that alone, the choice of whether or not to keep up with what is going on politically right now, and just news in general, even the choice of whether or not to like keep up with that, I just don't know. Like even I'm going back and forth on it. Like I have a video that I made but this past month where I'm like, yeah, the 24-hour news cycle is like not useful to an average person. To like an average person that like wants a better world, the 24-hour news cycle is not empowering. Like it doesn't, knowing every single little thing that is happening with the rate at which things are happening right now, especially as it regards the current administration and Trump, always knowing like what is happening to the very T is not useful to a normal person. Like there's nothing one individual person can do by keeping up with everything that's going on all the time. I think with that in mind, the best thing to do then is to, I think I'm doing this wrong. I think I need to put blaze powder somewhere else. I think the best thing a normal person can do, or an artist, or just anyone, is decide on one thing or one area of things that they want to keep up with and let all the other new stuff just kind of fade into noise in the background. I just don't think it's viable for most people to constantly have their pulse on every ridiculous thing that is happening all the time. I just don't think we're built for that. I just don't feel like we are made or biologically engineered to do a good job of understanding everything that's happening. And in fact, I've always argued that, I haven't always argued, but I've come to the conclusion that with things being as hard to follow all the time, this potion did nothing. I have achieved nothing. It's my position that like we shouldn't be in a world where so much is going on that no one person could possibly make sense of it all. That's how like these 24-hour a day, not 24-hour a day, but like these daily news streamers exist. Like how is it that we have someone on Twitch who can literally just talk about what the White House is doing all day, every day, 365 days a year? How is that even a thing? How is it that the government is allowed to move so uselessly slow when your needs need to be met, but then when it comes to making decisions without your consent or information, it can move at fucking breakneck pace? How the fuck is that possible? I say choose a couple of things that are motivating to you, a couple of things that you think will make you better, that will make you more effective in playing your individual role in the greater context of the fight, the revolution, whatever you want to call it. Figure out what you can do well and stick to that, and have friends who can pay attention to the other stuff, because no one person can do it alone and stay up to date. That's what I think. I know that I have a weird fixation on learning stuff, so I'm gonna do what I'm doing now, which is stream reading a Supreme Court case and learning about it and using that to inform my opinions, and then sharing that with others. If I didn't like learning stuff this way, that would not be the optimal choice.
Emphasis added. Against that backdrop, a true mandate of police action would require some stronger indication from the Colorado legislature than shall use every reasonable means to enforce a restraining order, or even shall
Be so
arrest
deadass right now.
or seek a warrant. Sections 186803.5.
Uh-oh, I'm gonna get lost in here.
A-B. That language is not perceptibly more mandatory than the Colorado statute, which has long told municipal chiefs of police that they shall pursue and arrest any person fleeing from justice in any part of the state, and that they shall apprehend any person in the act of committing any offense, and, forthwith
They shall,
and without any warrant, bring such person before a competent authority for examination and trial. Colorado Reverend Stat Section 31-4-112, Lexus 2004. It is hard to imagine that a Colorado peace officer would not have some discretion to determine
I'm gonna
that
die.
despite
Oh, that
cause
sucked.
to believe a restraining order has been violated,
Uh-oh.
the circumstances of the violation
All
or
right.
the competing duties of
I'm
that
back to whatever I was
officer or his
doing.
agency
Probably gonna run out of
counsel
food at this point if I'm not
decisively
careful.
against enforcement in a particular instance.
Hypothetically, I've been
practical
growing
uses.
carrots.
8. Respondent in fact concedes that an officer may properly decide not to
Where are the rest
enforce
of the
a
carrots?
restraining order when the officer deems a technical
Where the hell did the carrots
violation
go? That's
too
all I got? That's
immaterial to
dumb.
justify arrest. Respondent explains
Whatever.
this as a determination that there is no probable cause.
I'm gonna have to find this on my own.
Brief for Respondent 28. We think, however, that a determination of no probable cause, cite as 545 U.S. ______ 2005. Opinion of the court. 13.
I think that alone is a great topic to cover. The feeling of, is it worth knowing all the time? Because half the time it doesn't feel very good for me. Ignorance is a good false sense of safety. I don't think we should ever incentivize or make room for true ignorance, but I think we should respect the reality that, like, a human only has so much bandwidth. One person only has so much bandwidth. I think in alignment with recognizing that, I do have plans for a video eventually on purity politics. This horrible tendency for anyone on the right or left, not that I don't have a preference for not racist people over yes racist people, but I think purity politics is just a fucking plague on society, because it creates these standards of, like, you need to be this perfect this much all the time, and one person can never be fallible, one person can never make mistakes. Okay. Yeah, the idea that like you always have to know every single issue all the time, and you always have to be right. You always have to do right. You never can just recognize it's purity politics is incompatible with the reality that like no one person can do everything good all the time. Some people will do some good in their own way, and that should be enough for a well-intending person to act with good intentions and produce good outcomes. That should be enough. And so this game of purity politics pisses me off because it's like, how the fuck is one person gonna like, you know, how is one person gonna be able to do all of this shit while working 40 hours a damn week and just trying to survive? So, I don't know. I think, yeah, we should definitely incentivize conversations about like, hey, oh man, I'm gonna get murdered. Yeah, it should be fine. Who cares? And then what's my plan for this? Do I like break into there and tower over or something? Because these guys are just gonna keep killing me. I'm fine with this. Yeah, I don't know. Is it worth knowing? I saw, and I'm tired of stealing it from Hank Green because I keep watching him, and as a science teacher and someone who makes videos, like I just what he has to say is pretty relevant to a lot of what I think. I saw him say that a lot of people are anxious right now about the state of the world, due in part to the fact that they just don't have enough information. And so everyone is seeking to constantly keep up with the 24-hour news cycle because shit is happening and being reported faster than I think any one human brain could reasonably process. I just don't think things affecting all of society were ever happening this quickly throughout our evolutionary history. I just don't think that was happening. I don't think that I don't think that like the average person has ever had to face such a sheer amount of society collapsing things happening without any of their consent, without any of their input, without any of their power. Like, yes, people have lived under kings and monarchs and matriarchs and patriarchs for, like probably like 500,000 years. We've had community leaders that are in positions of power and hierarchy. We've had these things, but it's another ballgame altogether to have shit happening at scale to hundreds of millions of people this quickly. Like, that's not normal. And I just don't think anyone can process it. So rather than like looking at ignorance as a thing that maybe can be validated, I think instead we should just uplift the idea that people need to start seeing themselves as pieces of a puzzle or parts of a machine, not numbers. Like, a person plays a role if they want to play a role. No, not everyone has to, but everyone can play a role. And as a consequence, no one person has to be perfect and keep up with everything and take action on everything. That's what I think we should work towards. I'm a big fan of like pluralism. The idea that like there's a lot of us and no one person has to be like perfect in one particular way. When instead a person could do a perfect job of being themselves and having that be enough. Perish. Oh, the child zombie is going to kill me. I will not survive this child zombie at all without a freaking sword too. Like, that's not happening. Yep, that's not happening. Yep, okay. Some bullshit. I'm literally gonna have to go grab this sword and beat those guys up. Why the hell am I asleep? Yeah, fuck it, go to sleep. It'll work out. Spent their whole life keeping up on relevant topics, but a lot of them become irrelevant in the future. You wind up looking back and you could have spent time with themselves. Yeah, you could. Why spend all of your time trying to be 100% up to date on every little niche topic when instead you could try to build a worldview that is itself way more resilient and way more useful? I don't remember what it's called in philosophy, but like having a person's beliefs and skills be generalizable is a valuable pursuit. And in philosophy, right, there's this pursuit of like, I can't possibly make determinations of what is moral or not manually for everything I'll ever experience in life. But what I can do is create generalizable principles that I can rely on. Instead of trying to be the master of every individual topic on the news, we should try to be masters of where we stand and what we do. Which I think Stoicism talks a fair bit about. Old Marcus Aurelius and the old Stoics talk a lot about that idea, even though I don't love their philosophy in its entirety. Yeah. For me, it's like, I don't know. I can't possibly cover and talk about every single thing on this channel, even though like there are streamers that will do that all day, every day. But for me, like the goal isn't to know everything. The goal is to like do right by other people and build a better world. And you don't have to know everything to do that. And in fact, spending our limited time on this planet trying to know every little social thing is useless. I think there are certain specific things that are worth knowing more about than others. And to some degree, the whole premise of the quiet part is to find those things and learn them really well. Because those things are the key to developing an extremely resilient life philosophy that allows you to achieve your goals. And it allows me to achieve my goals in my case. If I can just learn the things that are missing from the puzzle that prevent average people from being fully empowered. Not that being average in any way is an issue. Who cares? People talk too much about like being above average. I don't really care. Did I do what's right? That's what matters to me. Did I do what's right while I was alive and here and able to affect the world? Did I do what was right? And talking about policing in this video alone is like a big part of that, right?
13.
Did I stand by while policing remained the way it is?
In a case such as this one,
or did I learn about it and try to understand it, encourage other people to learn about it, and push for a world where we deal with how fucked up this is?
Seattle, 65 Washington Ave, 661, 671, 672,
All right.
831 P.
That's empty. Oops.
1104, 1992. There is a vast difference between a mandatory duty to arrest a violator who is on the scene and a mandatory duty to conduct a follow-up investigation to locate an absent violator. A mandatory duty to investigate.
Okay, I'm memorizing the route. This is good. This is a very good outcome.
Priority, duration, and intensity. The dissent correctly points out
and I must have died over here, but it's been more than 5 minutes, so I cannot get over there right now.
Domestic violence. Mandatory arrest statutes have been found in some states to be more mandatory than traditional mandatory arrest statutes. Post at 7:13.
Looks so crazy now. I haven't played since before Caves and Cliffs. Oh, I literally just haven't played since like the last long stream I did of playing this. And there's all kinds of new stuff already. There's like a little pouch that expands your inventory, and there's leaf litter like beneath trees. There's like a buildup of leaves on the ground that you can pick up. They keep adding stuff. It's so interesting.
803.6 1 Lexus 1999. When a peace officer determines that there is probable cause to believe that a crime or offense involving domestic violence has been committed, the officer shall
without undue delay, arrest the person
suspected of its commission.
Okay.
Even in the domestic violence context, however, it is unclear how the mandatory arrest paradigm applies to cases in which the offender is not present to be arrested.
Shit, that's gonna suck.
As the
Get me out of here.
Explains,
Get me out of here.
At 9:10, and N8.
Shit.
Much of the impetus for mandatory arrest statutes and policies derived
Did I
from
dodge
the
it?
idea
I
that
did.
it is better for police officers to arrest the
It's better
aggressor
to
in a
arrest
domestic
them than
violence
to attempt to
incident
mediate
than
the
to
dispute.
attempt to mediate the dispute or merely
What
to
bearing
ask
does that
the
have on this
offender to
conversation
leave
right
the
now?
scene. Those other options are only available, of course, when the offender is present at the scene. C. To believe a violation has occurred is quite different from a determination that the violation is too insignificant to pursue.
Okay, so again, it's this
14.
idea of they're
Castle
really
Rock
saying that like
v.
police can just
Gonzales.
determine like, oh,
Opinion of the court.
this isn't worth pursuing. How
Hannah,
is
no
worth
right to
worth
choose.
pursuing even a
Mandated
thing?
victim participation in domestic
Is it
violence
illegal? Yes or no?
prosecutions.
Okay, if it's illegal, then
109
you take
harm.
action. Isn't that like your
L.
one job?
Rev. 1849, 1860,
It's just so absurd to hear on paper.
1996. T.
I understand how this would create like procedural difficulties, but it'd be much better to have it be the base precedent. What is your goal for the world? End Dragon building? Yeah, I'm just trying to beat the game, but there's no way I'm going to beat it before I'm done researching this topic. So the topic will likely... I'll know what I need to know about Castle Rock versus Gonzales long before I beat the game, probably. Okay, but here's what I don't get about this exact last point they just made. They're trying to make the reasoning that, like, police officers can't possibly respond to every little tiny crime. So it's going to be okay to just ignore people sometimes. Okay, maybe instead of doing that, like, we find a balance. The fact that they're ending on... the Supreme Court is ending on, it's better to make it legal for cops to not do their job than it is to make it illegal and then create a system for, like, recognizing when, maybe they weren't acting appropriately. Like, what? Would it not be a better default in a country built on, like, resisting the government from impeding on people? Wouldn't it make sense in such a country to be like, hey, the police do have an obligation to do their job, and they are not allowed to not do their job. They have got to actually do their job, and they're not allowed to weaponize not doing their job for harm, which is 100% what happened when this lady lost her 3 children and got them murdered because the cops refused to enforce a freaking restraining order. How is the default not... Cops are obligated to do their job. And, whatever complications come out of that, we will deal with on our own. Oh boy. Here we go. This is going to take a while. Oh yeah, it's going to hurt. Ow, 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 ow. Oh, wow. Okay, I really need armor. And I just keep kind of refusing to put any on. Uh-oh. I'm gonna have to take what little food I have left with me and try that again for the 5th time. What I need to bring is a bunch of cobblestone, and I'm clearly not bringing it. So here we go. Cobblestone. Nether bricks. Should be good. Yeah, again, would you rather, like, you could pose this to an American and, like, have them vote on it. Would you rather live in a country where the police have an obligation to protect you, but that means there's more enforcement? Or would you rather live in a country where the police don't have an obligation to do their job or protect you, but it means you can skirt your way around the law more often? Like, obviously, an American that understands, like, the premise of the Founding Fathers would be like, the government should do its job while also not violating my rights. It should be able to do both. We're the greatest country in the history of the world, supposedly. We're the richest country in the history of the world, literally. It should be able to do both. The police should be able to protect the citizens because we require them to do that one thing. We give up freedoms through the social contract for that one thing, which is protection, safety, and security. So, yes, the police should be obligated to do their job. And they should be obligated to do it in a way that doesn't infringe on people's rights. That should not be that complicated. One of these fuckers is about to manifest, isn't it? Oh, 2 of them. Not good. Get out of here. Okay, let's see if they come down here. Come down here, idiot. Really? You're not coming down here? There we go. There we go. That's what I want to see. Eat. Eat and stop being burnt. Blaze rod. Okay, I got 1. I'm gonna try to get 2, maybe. No, I'm not. I'm gonna go get I'm gonna go make fire resistance potions. Create a movement by saturating the police force with better people and make the change from inside out, become a police. So there's a synthesis between the 2 extremes of put the fire out from inside of the house, which famously and I generally agree, I don't really think we can fix policing by putting in new people. I personally don't see that. From my research and from the conclusions I've made, I just don't see a world where we can fix policing just by having better officers. We need better definitions of what policing is. And we need much better regulations for what police can get away with. We need to get rid of qualified immunity, for example. Which, in a way, by changing the regulations, you would naturally change the police force to likely be better. Because if you got rid of qualified immunity, it would mean that the only people who are police officers are people who are really consistent about their intentions to not do anything unconstitutional or unethical. They would be super aggro about not fucking it up, because they could be personally liable for fucking it up. So I personally am on the side of just completely abolish the police. But that doesn't mean I think that like that's going to specifically happen or that I'm going to convince a lot of average Americans of that. So instead, what I find more interesting is a synthesis between putting the fire out from inside of the house, which is by, putting in more good cops to push out the bad cops. There's a synthesis between abolishing police and building a better police force. And it's just called civil defense. There's an entire body of theory and history of it being done of civil defense, where people, man, do I not remember how to make a freaking potion in this game? Okay, I've made a mundane potion. Maybe next I need to put this into it. Am I dumb? Let's see. It looks like I don't remember how to make freaking potions in this game. Oh my god, I don't. I'm gonna have to Google it. Yeah, community defense or civil defense is the kind of shit that the Black Panthers were on, where they figured out like, hey, we can have order and rules without having a government or state or police force be the ruler. There's a way to do that, and some like examples of like how that works is like restorative justice, which a lot of schools use and a lot of prisons, not prisons, but prison adjacent services attempt to use, which is like we can have justice without having a traditional cop with a gun doing the job. You can do it by having normal people in your community who are behoven to the community far more than a cop with qualified immunity. You can have normal people like elected cops essentially, who don't necessarily have guns and instead have a much wider variety of things that they do. You can have those people doing the safety and such work instead of traditional police. So in a way, like if I had a perfect world, I would just abolish all police forces and require every community to create a civil defense force instead. I would require that every single officer be vetted by voting through that community. Maybe it'd be a panel of other voted people, but that's how I would do it. Is it'd be essentially volunteers that get elected based on their skills by a board or something. Maybe like the city council or a group of people of the city council of elected representatives. They vote on who gets to become a civil defense officer instead of a cop. And obviously, basic police reforms would be like, hey, instead of sending everyone out with guns, we're going to send people out with with different skills and different equipment to different scenarios and situations, instead of having this one centralized police force that's, you know, a Swiss Army knife for every situation. Instead, you have independent tools. Not that every cop is a tool, but you would have these civil defense officers be specialized to their skill. You would use the right tool for the right job instead of a universal, extremely overfunded, qualified immunity tool to do the job. You would have elected community members who are civilly liable for their conduct and are experts in a given field responding to each of these issues. Policing would be dealt with. The problem would just go away. and so that's called civil defense. And the Black Panthers did it. There are communities throughout human history that have done it in certain ways. Like right-leaning American libertarians will sometimes talk about like the Second Amendment and how the point allegedly was for the average person to own a gun and be civil defense in that way. So it exists across the spectrum. Alternatives to traditional policing. I am very interested in any of them. Whatever works. All right, I have to remember how to make a fire resistance potion. Potion ingredients. I think I need a magma slime or whatever. I need a slime. I think I just remember that I need a slime dude to do it. So I need nether wart. I need to kill a magma slime. And then a water bottle. So first, I need to enchant a plain one. Then add nether wart. Then add the magma slime. Okay, so let's try this again. Mundane potion, no effect. So what happens if I drink it? Does anything happen? Nothing. Okay, cool. I am now just drinking water, I imagine. Oh, stop. Yeah, sure, whatever. There we go. Okay, I need to go kill a magma slime then, if I want to have proper fire resistance. But I am quickly running out of food, so this is going to be an issue, definitely. Let's keep reading.
Person suspected of its commission.
Yeah, that's definitely how I feel. Supreme Court is saying, like, hey, it's better to let police officers not do their job sometimes, and then it's just incompatible. The reasoning doesn't make sense. You cannot say, yes, police are allowed to not do their job sometimes, discretionarily, and qualified immunity exists. You get one or the other. One or the other makes sense.
Policies derived from the idea that it is better for police officers to arrest the aggressor in a domestic violence incident than to attempt to mediate the dispute or merely to ask the offender to leave the scene. Those other options are only available.
I need magma slimes. Go away. Can you fuck off? I'm not dealing with you in your dumbass looking pants. You're kidding me.
To believe a violation has occurred is quite different from a determination that
Alright, where the hell can I get a magma slime? I don't see any on the map right now. I did see some this direction though.
Castle Rock v. Gonzales.
I wonder if I can kill you without dying.
Hannah, no right to choose.
That didn't even give me anything, did it?
Mandated victim participation in domestic violence prosecutions. 109 Harv.
Mandated victim participation in domestic violence prosecutions?
1860, 1996. T. He clear trend in police practice is to arrest
baby magma
the
slime
batterer at the scene.
Ow, you jerk.
Emphasis added. As one of the cases cited by the dissent, Post, at 12, recognized, there will be situations when no arrest is possible, such as when the alleged abuser is not in the home.
But then the police should have a responsibility to go find the abuser.
65 Washington app at 674 831
Got it.
P 2D.
Go away, magma slime.
At 11:05. Emphasis added. That case held that Washington's
no magma
mandatory
creams.
arrest
That's not
statute
good.
required an arrest only in cases where the offender is on the scene, and that it d.id. not create an ongoing mandatory duty to conduct
Sorry,
an
that's
investigation
insane.
to
There's no
locate
way
the
I'm reading this
offender.
right now. What? No right to choose. Mandated victim participant. Okay. The other options are only available, of course, when the offender is present at the scene. See Hannah. No right to choose. Mandated victim participation in domestic violence prosecutions. The clear trend in police practice is to arrest the batterer at the scene. As one of the cases cited by the dissent post at 12 recognize there will be situations when no arrest is possible, such as when the alleged abuser is not in the home. The case held that Washington's mandatory arrest statute required an arrest only in cases where the offender is on the scene and that it did not create an ongoing mandatory duty to conduct an investigation to locate the offender. That is insane. What is the point of police then? I thought they had one job, which was to take charges of violating a law, put them on a person, and then seek justice through the justice system, the courts, which means detaining that person and arresting them if detaining is necessary, which when it comes to domestic violence, I can only imagine it's necessary to go find that person and investigate so you can put the charge on that person. Insane that it's just like there are states where it's just like, no, cops don't have to do their job at all, actually. What the fuck is the point then?
Offender ID at 675 831p 2D
Insane.
at
Fucking
11:05.
batshit.
Colorado's restraining order statute appears to contemplate a similar distinction, providing that when arrest is impractical, which was likely the case when the whereabouts of respondents'
Oh, Magma Slime.
husband
Alright, maybe
were
I can get him.
known. The
Come here.
officer's statutory duty is to seek a warrant
Come here.
rather than arrest.
I'm gonna let you hop one more.
Section
Get over here.
186803.5
You're not there enough. There you go. Good job. Nope. Come on.
3B.
Come on. There you go. Let's go.
Respondent does not specify the precise means of enforcement that the Colorado restraining order
No magma
statute
cream.
assertively
Okay, this is
mandated,
overall
whether
not a
her
good
interest
outcome.
lay in having police arrest her husband, having them seek a warrant
Oh, there's the other
for
one.
his arrest,
No?
or having them
No.
use
Where the
every
hell
reasonable means,
can I find more of the magma
up
dudes?
to and including arrest, to enforce the order's terms. Brief for respondent 2930.
These guys are still up here, right?
Such indeterminacy
You gonna spawn?
is not
Okay,
the
let's get
hallmark
out of
a
here before I
duty
die.
that is mandatory. Nor can someone be safely deemed entitled to something when the 9 respondent characterizes her entitlement in various ways. C.
What the hell are y'all talking about? Respondent does not specify the precise means of enforcement that the Colorado restraining order statute asserted mandated, whether her interest lay in having police arrest her husband, having them seek a warrant for his arrest, or having them use every such indeterminacy is not the hallmark of a duty that is mandatory. I don't understand. So, what do police actually do? Who fucking knows? That's why when I first sought to address the question of like, what is policing in America all about? The first thing I went to was body cam footage of them actually doing their jobs and what that looks like. And I have a video where I watched over 1,000 hours of police interactions, body cam footage of police doing their jobs. And it's not just, the videos I watched were not just of them like arresting people. They were a lot more complicated. I saw them doing investigations. I saw them, deliberating and talking about how they're doing their job. And after watching that, I concluded that police have a job that they usually do, which I guess now I understand them to not have to do. But a police's job in the United States is to have charges, which are names of crimes a person could commit. They take possible charges for committing a crime and they link those charges with a person. And then they do a couple of possible things depending on the severity of the charge. They can arrest a person, they can detain and investigate and cite a person, which may or may not involve a fee. I forget what you call when it's a fee specifically, but they can arrest a person, book them in, hold them in jail, and then based on the judicial system, they may or may not be held in jail for a while. and then the courts fully take over, and those courts determine typically if they end up in prison long term. So police's job is literally one thing: take charges and glue them onto a person. That's it. That's it. They investigate to verify that they have probable cause to put a charge onto a person. And then they do a couple of things based on the charge. They can detain them in a jail until the courts rule that person guilty or not, and then put them in prison or not. Or they can cite a person right then and there and make them pay money. That's it. That's a cop's job. That's what they do, according to thousands of hours of me watching what they do. That's what they do. They take charges, they put it on a person, they either arrest or they cite them. That's it. I never once saw that they have a duty to protect people, ever. In all the thousands of hours I watched, they don't particularly have a duty to protect people. They don't have a duty to. It doesn't seem to be required. And obviously the Supreme Court case is reinforcing that. Now, the bigger question becomes, if they don't even have a duty to enforce, because policing is a discretionary job, that's the word they're using for this, then what do cops do? Nothing. They don't have to do anything, really. If you throw on qualified immunity, the fact that a cop cannot be found, I believe, civilly liable for doing their job inappropriately or hurting a person, for example, or committing a crime during their job. What do police have to do? Nothing. Literally nothing. Like from a civilian standpoint, like, what do the cops have to do for me? What are they required to do for me? Nothing. Literally, actually nothing. So that's insane. Really don't know how to make of that because it's so insane.
Brief for respondent 12.
Well, I don't think I'm beating Minecraft before this is over, unfortunately. That sucks.
ID at 13. Interest in police enforcement action. ID at 14. Specific government benefit consisting of the government service.
Alright, what am I doing in the game right now? I'm looking for magma creams, but I'm not going to beat it before time runs out. Not that time will particularly run out, but
at 32. T.
I just can't get any damn carrots.
The order here mandated the arrest of Mr. Gonzales under specified circumstances, or at a minimum required the use of reasonable means to enforce the order. Cite as 545 U.S. _ 2005. Opinion of the court. 15. Identity of the alleged entitlement is vague. See Roth, 408 U.S.
The issue is I literally don't have enough food to keep going back to the nether, so I don't think I'll beat it.
Considering whether certain benefits were secured by rule or understandings. CF Natale versus Ridgefield.
If the police don't protect people, would having a subcategory of enforcement specifically meant to protect people be a better answer? Probably, yeah. I mean, I'd be fine with that too. I still think what an average police officer is and represents in our country, in the United States, shouldn't exist. I still don't think, like, if a cop is going to be a person in a cruiser with a gun, I still don't think that person should exist, because that person responds to all calls. If a city or state were to be like, hey, we've created a new subcategory of officer. It's not just a law enforcement officer. It's not just a peace officer. It's not just a sheriff. It's not just a deputy. We have created a new subcategory, and their singular job is to respond to calls, and they have to actually do their job. It's really hard to not say that, but like, that's what they're not doing, is their basic job. Yes, a dedicated subcategory of cop that has to do their job. I don't think that'd be a bad idea. But to some degree, in a way, that's what investigators are, because the investigators are the ones who are going to actually do the investigation and follow it through to the end as far as they possibly can. Then you create a new sub-problem, which is, at what point have they tried hard enough, right? There'll be this issue of like, at what point have they tried hard enough to find your husband? Like, what if in this case the husband like hid out and went really fucking far into the backwoods, and months went by and they still couldn't find him? At what point are they allowed to give up the case? That's when I would think discretionary kicks in. But I think the idea in this case, especially with this Supreme Court ruling, is it's not that the police gave up on trying to find her husband or trying to find her kids, or in this case specifically enforce a restraining order. They didn't even try in the first place. It wasn't even just that they failed to see it to its end. They didn't even start it. So rather than even creating a new subdivision of police officer who will see it, at least start it. Maybe they don't always see it to the end, but at least they start it. At that point, just have every police officer have a legal obligation to at least start responding. Is it true that police departments have a procedure for responding to cases? Absolutely. But the procedure and the flexibility that procedure afforded those police officers is the reason this woman's children are dead, and her husband too. He was a terrible person, but he did death by cop because no one tried to stop him in the first hour of him taking the kids, which is what should have happened. So rather than even making a subcategory of enforcement that's required to enforce safety orders, you just make every cop be required to. But the discretion then isn't in starting. The discretion is in when have you done enough. And I think police departments could totally come up with procedures where it's like, hey, if X thing happens, because there's like a truth I feel like that isn't talked about enough. The cops do have a very diverse set of responsibilities, but so do teachers, right? We might have different levels of risk, allegedly. Not that teachers don't get shot up. The important context here, if you don't know, is that I am a public school teacher. The police have a diverse set of responsibilities, and I talk about this in my video on policing titled ACAB. Police have a diverse set of responsibilities. Teachers have a diverse set of responsibilities. Teachers still do them. And are still required. So, like, for example, teachers are legally bound to provide children something called a free and appropriate public education. We and schools are legally required to provide students a free and public education. It's called FAPE. It's a constitutional precedent. Teachers literally have to do it. If they fail to do it, their school can get shut down. When a cop fails to, it kind of depends on how you define it based on the court case. We could say, for example, the court ruled that police do not have an obligation to protect the liberty of people from other people. They only have an obligation to make sure they themselves as police do not interfere with a person's existing liberty. So that was the ruling, the precedent ruling for this Supreme Court case, was that police and the government in general don't have to protect you from other people. They have to protect you only from other aspects of the government. Which, I mean, at that point, like, the case is just closed and shut. It's objectively true that the police have no obligation to protect you from anything other than other cops, which they don't even fucking do. And the reason they don't is because of qualified immunity. So, yeah, I don't know. I just lean abolish cops, rebuild it from the ground up, do it better, do it in a way the founding fathers would have respected. Where if we're going to make sacrifices of our personal freedoms and pay taxes, which the founding fathers hated, if we're going to do both those things, they better fucking protect people. And they better have a legal obligation to do it. And if teachers can do it, despite the number of responsibilities we have and how crazy broad they are, right? Some cops are going to respond to trespassing, where someone who's, completely off their rocker won't leave a McDonald's. They're also going to respond to domestic abuse. They're going to respond to rape. They're going to respond to murder. They're going to respond to traffic violations. They're going to respond to jaywalking. They're going to respond to all these crazy things. It shouldn't be impossible for them to be legally required to protect people and to protect people's life, liberty, and pursuit of happiness. I don't think they should be legally required to see everything to its absolute end because the resources aren't there for that. And I agree that's not reasonable, but they should be required to start. So if someone tells them, my husband has taken my children, they should be legally required to respond. There should be no world where they are not legally required to respond, because if not, why do they exist? And I don't think it'd be inappropriate to put that responsibility onto all police officers. I don't think it would be impossible to do that. We do it with teachers. Teachers similarly play 100 roles for society. We are counselors. We are mental health responders. We are baby nurses. We are emotional support for children. We break up fights. We have a million responsibilities, and yet we still, with no issue, are legally bound to do our job. And teachers don't have qualified immunity. If I fuck up, if I hurt a kid, I can get sued for it. That's completely agreeable. I shouldn't hurt a kid. And any, reasonably made justice system or court of law should be able to be like, oh, this kid was about to fall down the stairs and you grabbed their wrist and you accidentally sprained it. You are not going to jail, right? That should be common sense. So we should be able to trust the judgment of a jury of our peers or a judge enough that it's like, yeah, they will deal with the in-betweens. It can work in education. It should be able to work in policing. I think anything else is genuinely just an excuse from cops.
170F, 3D 258, 263, CA 2 1999. There is no reason.
I'm on page 15 and 20. There is no way.
That will preclude
There's no way I'm pulling this off.
federally protectable property interest to the uncertainty that inheres in the exercise of discretion. The dissent, after suggesting various formulations of the entitlement in question, ultimately contends that the obligations under the statute were quite precise: either make an arrest or, if that is impractical, seek an arrest warrant, post, at 14. The problem with this is that the seeking of an arrest warrant would be an entitlement to nothing.
Damn it!
but
I'm
procedure
cooked.
which
There's
we
no
have
way I've
held
gotten good at this.
inadequate even to support standing. See Lujan versus Defenders of Wildlife.
No, I totally agree. Yeah, some countries have free healthcare. It's no excuse that the U.S. can't do it. Safety should be a similar priority. Yeah, like it should be able to be pulled off. I know a lot of people will they'll bully like the UK's police force and be like, they only have their sticks, they don't have guns. I'm okay with that. I think a police force, like really, that should be plenty. Because a lot of what those people are going to be responding to, a lot of what policing actually is traffic laws. A lot of it is just like breach of peace when someone is drunk and doing something crazy. Which arguably, breach of peace is regularly a charge that's used for violating people's civil rights, in my opinion, and what I've seen. But no, like it shouldn't be impossible to build a country where the police are obligated to not ignore crime, at the very minimum. That shouldn't be like a heavy ask. That should be like the most basic, like, we pay taxes, a lot of taxes. We give up some of our freedoms, right? For example, like there are limits on self-defense in the United States. In a lot of cases, like if you defend yourself in the wrong context, you go to prison with the person that assaulted you. That's kind of absurd to say aloud, right? Like someone was, put a knife to me and I shot them dead and I am going to prison because when they noticed my gun, they turned their back and ran, but I shot them anyway for fear that they might come back for me. That person is going to prison because they did more than what the law allows for self-defense. That is a trade-off that we make. That is the social contract. It's like, hey, I'm not allowed to just body people in self-defense on a daily basis because allegedly we have police officers that will take that responsibility away from me and do it instead. But I say allegedly because it doesn't matter if the police are not obligated to actually hold up their end of the bargain. And again, the existence of like qualified immunity really disgusts me in that context. Like knowing that this is the Supreme Court that these cops are working with, and yet they still have qualified immunity just is insane to me. One or the other. It has to be one or the other. Cannot be both. You cannot get qualified immunity and a lack of an obligation to do your job. Those two things can't, like, they don't make sense together. I don't know why, but the game is suddenly hitching like insanely badly right now. So I'm going to save and quit real quick and load it back up because that is some weird behavior. Is it this one? I don't even remember. Okay, let's get through the rest of this document.
Wildlife 504 U.
Fish and Wildlife. Defenders of Wildlife. What is this?
1992. Much less can it be the basis for a property interest. See post at 34.
Oh, it's just vacuuming.
Suitor,
Okay.
J. Concurring.
Where can I find a magma slime?
It remains within the discretion of a judge whether to grant it.
Where?
And after it is granted, it remains within the discretion of
discretion. Policing in the United States is discretionary. That's my big learn from this entire thing, is that policing in the United States is not compulsory, it is discretionary.
Out of which a property interest is created. Even if the statute could be said to have made enforcement
policing is discretionary, but funny enough, education is compulsory. You have to send your child to get an education, or provide it yourself. Either way, your child has to be educated, but the cops don't have an obligation to protect you. Teachers are obligated to educate. Cops are not obligated to cop. Insane. Genuinely don't know what to do with that. Like, this is the sort of thing that I think, in alignment with the quiet part, you're not supposed to know. But Americans aren't supposed to know this. They're supposed to believe that America is like this flawless freedom utopia.
Protection from her husband. Post at 21:22.
That's what Americans are supposed to believe. They're not supposed to realize that, like, no, their police are lazy as fuck. And allowed to be lazy as fuck.
Asserts that the police would lack discretion in the execution of this warrant. Post at 13:14 and 12, but cites no statute mandating immediate
Oh, I'm so
execution.
lost. I also don't have enough food.
The general Colorado statute governing arrest provides that police may arrest a warrant commanding arrest.
Like, is there... I'd love to learn, even though I'm slowing the reading down again. You know, I would love to learn. I would love to learn that individual states have like a level of violence where it's like, hey, the police, it's not that they may arrest, it's that they have to make meaningful documented attempts to arrest someone if, for example, they have a gun. Like, don't tell me that the consequence of this ruling is that the police could see a dude with a gun and just not even go after him, right? That's the plot of Spider-Man, by the way. It's like Peter Parker, when he first gets his powers, he's just like, hey, you know, it's not my job to go get this guy. And actually, in one of the comics and one of the animated series for Spider-Man, because only I would know this, of course, he actually says, like, oh, I'm not the cops. I don't have to go get this bad guy. It's funny because, like, that assertion is wrong. That social assertion that, like, I don't have to go get the guy with the gun because the cops have to go get the guy with the gun, not me. That's not even true. But it's funny, right? Like, Peter Parker has the power and ability to stop the robbery that ends up killing his uncle as Spider-Man, but he doesn't. He doesn't believe he has that obligation internally. And so he doesn't go after the guy, and it's that exact guy that ends up killing his uncle. And then, you know, he learns his lesson and moves on. Policing in America has not learned that basic lesson that Spider-Man fucked up once and automatically learned. Fucked up one time, a singular time, and automatically learned that lesson. It's a great comic. Many of the different iterations of Spider-Man are all consistently really good stories. Very good stuff. Yeah, it's interesting. The Supreme Court has decided that that Spider-Man doesn't have to do it, even though Peter Parker himself would make that choice in a millisecond. The Supreme Court is going to say no, cops don't have to do the right thing. Weird. Very weird to even read that aloud and know it. I wonder how many average people even know this about policing. I bet a lot of people know that, like, cops can suck. But typically, wow, I cannot believe I just fell that far.
Opinion of the court.
I think a lot of people know that cops can suck, that cops can be lazy, that cops can be ineffective, and that cops kill a lot of black people in the US. I think a lot of average people know that. But how many of them know that legally cops really just can't even be that good in the first place because they aren't required to legally be good?
Obligatory can serve various legitimate ends other than the conferral of a benefit on a specific class of people. See, e.g., Sandin versus
How the hell do I get out of here?
515 U.S. 472, 482, 1995, finding no constitutionally protected liberty interest in prison regulations phrased in mandatory terms, in part because S.U. guidelines are not set forth solely to benefit the prisoner. The serving of public rather than private.
I can only wonder what's wrong with the game right now that it's suffering like this. I really don't know.
Besides the injury they do to individuals, strike at the very being of society, which cannot possibly subsist, where actions of this sort are suffered to escape.
Heavy quote. Sandin versus Connor. The serving of public rather than private ends is the normal course of the criminal law because criminal acts, besides the injury they do to individuals, strike at the very being of society, which cannot possibly subsist, where actions of this sort are suffered to escape without impunity. Heavy writing, completely ignored, clearly.
Escape with impunity.
Completely ignored in the ruling of this case.
Blackstone, Commentaries on the Laws of England 5,
Leave me alone.
1769.
Leave me alone.
See also Huntington versus Attrill, 146 U.S. 657, 668, 1892.
I am just not traversing this biome right now at all.
Underlies, for example, a Colorado district attorney's discretion to prosecute a domestic assault, even though the victim withdraws her charge. See People versus Kuhn.
I specifically think that if you believed in a legislative system, judicial and executive, so that's criminal and policing, if you believe in a policing system and a judicial system that is just and true, if a woman charges her husband as having been an abuser, and she, for some unknown and likely toxic reason, withdraws her charge, if the criminal justice system has any value to it, the prosecutor should still absolutely go ahead regardless of her withdrawing that charge. Because if the guy beat his wife, he should be in trouble. It shouldn't be that complicated. Oh, but we want to make it so, if there's gray, well, if there's gray, that's what the judicial system is for navigating that gray, having a trial, and truly figuring out what this guy did and how bad it was. It should be impartial. It should be impartial.
People versus Kuhnfair, 102p, 3D 302.
Oh my god, I cannot find a magma slime. Where?
Colorado 2004. Bender, J. Concurring in part, dissenting in part, and dissenting in part to the judgment. Respondents' alleged interest stems.
I'm totally coked. I have no idea where these magma slimes are.
From a restraining order that was authorized.
I know what biome they tend to spawn in, but it's not nearby.
On which the Court of Appeals relied.
And now I understand Minecraft speedruns better. You really have to have a lot of things come together all at once.
Common law or contractual entitlement to enforcement. If she was given a statutory entitlement, We would expect to see some indication of that in the statute itself. Although Colorado statute spoke of protected person, such as respondent, it did so in connection with matters other than a right to enforcement.
Yeah, I don't even know what to do,
It
really.
said that a protected person shall be provided with a copy of a restraining order when it is issued, Section
Alright, let's see what's next.
18680.3a, that a law enforcement agency shall make all reasonable. Cite as 545 U.S. _______,
Oh boy.
2005. Opinion of the court.
I do not have.
17.
Yeah, it was nice chatting. Take care.
Efforts to contact the protected party upon the arrest of the
Oh my
restrained
God.
person, Section 18680.3.5.3d, and that the agency shall give to the protected person a copy
Why am
of
I
the
in a
report
jungle? It
it
is so hard to
submits
see.
the court that issued the order, Section 18680.3.5.3b. Perhaps most importantly, the statute spoke directly to the protected person's power to initiate contempt proceedings against the restrained person if the order was issued in a civil action, or request the prosecuting attorney to initiate contempt proceedings if the order was issued in a criminal action. Section 18680.3.5.7. The protected person's express power to initiate civil contempt proceedings contrasts tellingly with the mere ability to request initiation of criminal contempt proceedings, and even more dramatically with the complete silence about any power to request, much less demand, that an arrest be made. The creation of a personal entitlement to something as
This
vague
enforcement
and
restraining orders
novel as
cannot simply go
enforcement
without
of
saying.
restraining orders cannot simply go without saying.
Yeah, totally should be able to go without
Post
saying.
at 17 and 16. Stevens, J. Dissenting.
Yep, of
We
course.
conclude
John Paul
that
Stevens
Colorado
consistently
has
is a good
not
dude.
created such an entitlement. C. Even if we were to think otherwise concerning the creation of an entitlement by Colorado, it is by no means clear that an individual entitlement to enforcement of a restraining order could constitute a property interest for purposes of the Due Process Clause.
Wow,
Such
okay.
a right
This shit
would
is just not
of
happening.
course, resemble any traditional conception of property. Although that alone does not disqualify it from due process protection, as Roth and its progeny show, the right to have a restraining order enforced does not have some ascertainable monetary value, as even our Roth-type property as entitlement cases have implicitly required. Merrill, The Landscape of Constitutional Prop. 18. Castle Rock v. Gonzales. Opinion of the Court. Erty, 86 Virginia L. Rev. 885, 964, 2000. Point 12. Perhaps most radically, the alleged property interest here arises incidentally, not out of some new species of government benefit or service, but out of a function that government actors have always performed, to wit, arresting people who they have probable cause to
Of
believe
committing
have
criminal
committed
offense.
a
That is what.
criminal offense.
That's what
Point
their loop
13.
is.
The indirect nature of a benefit was fatal to the due process claim of the nursing home residents in O'Bannon v. Town Court Nursing Center, 447 U.S. 773, 1980. We held that, while the withdrawal of direct benefits, financial payments under Medicaid for certain medical services, triggered due process protections, ID, at 786-787, the same was not true for the indirect benefit, conferred on Medicaid patients when the government enforced minimum standards of care for nursing home facilities, ID. At 787. A. An indirect and incidental result of the government's enforcement action does not amount to a depre. 12. The
Jesus.
dissent suggests that the interest in having a restraining order enforced does have an ascertainable monetary value, because one may contract
Interesting
with a
reasoning.
private
That is
security
definitely...
firm to provide protection for one's family.
They are trying. The dissent is trying desperately
At
to
2,
do the
20,
moral thing,
and
which is
N
interpret the law in a
18.
way that prioritizes people's
That
well-being.
is, of
But they're
course,
really having to do
not
some
as
gymnastics.
precise as the analogy between public and private schooling that the dissent invokes. Post, at 20, N. 18. Respondent probably could have hired a private firm to guard her house, to prevent her husband from coming onto the property, and perhaps even to search for her husband after she discovered that her children were missing. Her alleged entitlement here, however, does not consist in an abstract right to protection, but, according to the dissent, in enforcement of her restraining order through the arrest of her husband, or the seeking of a warrant for his arrest, after she gave the police probable cause to believe the restraining order had been violated. A private person would not have the
Power to
power
arrest.
to arrest under those circumstances because the crime would not have occurred in his presence.
Okay.
Colorado Reverend Stat Section 16.3.201, Lexis 1999. And, needless to say, a private person would not have the power to obtain an arrest warrant. 13. In other contexts, we have explained that a private citizen lacks a judicially cognizable interest in the prosecution or non-prosecution of another. Linda R. S. v. Richard D. 410.
They're saying it's true. The people should be obligated to prosecute based on the evidence, regardless of what the person personally thinks.
Cite as 545 U.S. ______, 2005. Opinion of the Court. 19. That ion of any interest in life, liberty, or property. Ibid. In this case, as in O'Bannon, t. he simple distinction between government action that directly affects a citizen's legal rights, and action that is directed against a third party and affects the citizen only indirectly or incidentally, provides a sufficient answer to respondent's reliance on cases that found government-provided services to be entitlements. ID, at 788. The O'Bannon Court expressly noted, ibid, that the distinction between direct and indirect benefits distinguished Memphis Light, Gas and Water Div. Craft, 436 U.S. 1, 1978, one of the government services cases on which the dissent relies, post, at 19. 3. We conclude, therefore, that respondent did not, for purposes of the Due Process Clause, have a property interest in police enforcement of the restraining order against her husband. It is accordingly unnecessary to address the Court of Appeals determination, 366 F. 3D, at 11-10-11-17, that the town's custom or policy prevented the police from giving her
Yeah, I
due
can make 10
process
swords
when
real
they
quick.
deprived her of that alleged interest. See American MFRS Mutt. In's Company v. Sullivan, 526 U.S. 40, 61, 1999.14.
Okay, so I just do this like 10 times.
In light of today's
Maybe.
decision and that in DeShaney, the benefit that a third party may receive from having someone else arrested for a crime generally does not trigger protections under the Due Process Clause, neither in its procedural nor in its substantive manifestations. This result reflects our continuing reluctance to treat the 14th Amendment as a font of tort law. Parrott v. Taylor, 451 U.S. 527, 544, 1981, quoting Paul v. Davis, 424 U.S. at 701, but it does not mean states are powerless to. 14. Because we simply do not address whether the process would have been adequate if respondent had had a property interest, the dissent is correct to note that we do not contest the point posed at 2. Of course,
You know, it's funny, they always put the agreeing at the first part of the document and then the dissent at the second part. So every time I read one of these, I'm just like patiently waiting for it to suck.
Opinion of the court. Provide victims with personally enforceable remedies. Although the framers of the 14th Amendment and the Civil Rights Act of 1871, 17 Stat 13, the original source of Section 1983, did not create a system by which police departments are generally held financially accountable for crimes that better policing might have prevented, the people of Colorado are free to craft such a system under state law.
Okay, no, I literally cannot do this without food, so I think I'm gonna go make a fuck ton of food real quick. It's gonna be my only option.
The judgment of the Court of Appeals is reversed. 15. In Colorado, the general statutory immunity for government employees does not apply when the act or omission causing injury was willful and wanton. Colorado Reverend Stat Section 2410-118, 2a, Lexis 1999. Respondent's complaint does allege that the police officer's actions were taken either willfully, recklessly, or with such gross negligence as to indicate wanton disregard and deliberate indifference to her civil rights.
I would totally concur there.
Pet for Cert 128A. The state cases cited by the dissent that afford a cause of action for police failure to enforce restraining orders, post, at 1112, 1415, and 13, vindicate state common law or statutory tort claims, not procedural due process claims under the federal Constitution. See Donaldson v. Seattle, 65 Washington App, 661, 881 p. 2d 1098, 1992. City could be liable under some circumstances for per se negligence in failing to meet statutory duty to arrest. Matthews v. Pickett County, 996 S. W. 2D 162, Tennessee 1999. County could be liable under Tennessee's Governmental Tort Liability Act where restraining order created a special duty. Campbell v. Campbell, 294 N. J. Super. 18, 682A, 2D 272, 1996. Rejecting 4 specific defenses under the New Jersey Tort Claims Act in negligence action against individual officers, Soroschetti v. New York, 65.
So their main thing is that constitutionally the United States, no, like cops just don't have an obligation to protect people. They're like, oh, states can kind of like ask and require that in certain ways, but like, how are you not going to make that constitutional?
Weaver, 295 Oregon 702, 670 p. 2d 137, 1983, statutory duty to individual. Plaintiffs arising independently of tort law duty of care.
Duty of care. Individual plaintiffs arising independently of tort law duty of care. Is that it? That does in fact seem to be it. Okay. All right, interesting. So, I feel like I've said most of what I would typically say, and I am tired and have learned a fair bit. There's one more thing I would like to research with you all while I finish up. Okay, so I did not beat Minecraft. I got kind of close. I wasn't far from like getting Enderman. Maybe I'll save this and keep doing this sort of thing for future shorter streams. What is the general consensus on this court ruling? Constitutionally, there does not exist an obligation across all 50 states, coming down from the Constitution, for police officers to have an obligation to do their jobs at all. It's not even just serve and protect. It's just do their job fucking at all. They have no obligation to arrest or respond at all. There is no one constitutional thing saying that. Do individual states likely have these tort laws regarding their responsibility and duty of care? Sure, but there's nothing saying that that's universal. There's nothing guaranteeing that that's going to happen. And the fact that we live in a society with qualified immunity and without a country level obligation of police officers to do their job, to protect people, to serve, that is batshit insane. For the United States to call itself like a civilized bastion of culture and governmental excellence, for patriotism to exist in a country where police officers cannot face responsibility due to qualified immunity, and also there is no constitutional guarantee of police officers having a responsibility to do their job, to protect people and to serve, is insane. That is, it begs the question of, at what point is dystopia worse than just like primitivism? Like, at what point is human engineered violence and neglect by the government dystopia? At what point is that worse than just like fucking living in the middle of the woods and like protecting yourself? Like, at what point is the dystopia worse than the very same primitive savagery that the colonizers of this country once criticized? At what point is our dystopia worse than anything we could ever imagine considering without government in so-called chaos? It begs that question, and I'm quickly approaching answering it by saying I would literally prefer anarchy and anarchism and rules without rulers above living in this dystopia that we currently live in. Here's the biggest question I have. Were the police... Oh, can you even see my screen right now? Okay, yeah. Okay, you just can't see all of what I'm typing. The officers in Castle Rock v. Gonzales. Yeah, sure, convicted. Did those police officers face any consequences? This is what I want to know. Did these police officers ever face any? I have no way of publicly seeing if they were held accountable. Are you being real? Like, Uh, okay. Um, what is the name of the woman again? Jessica Gonzales. That ignored Jessica Gonzales. 2004, Seattle Times. Archive. About 20 states in 2004 have laws providing for the enforcement of restraining orders, making them vulnerable to lawsuits if Gonzales' claim is upheld. Eight hours later, Gonzales, who were the cops? Be so real. Who were the cops? How are we not allowed to know who they are? Like, what amount of digging will I have to do before I figure out what this is? No. Let me find them. I don't know. I'm looking up, and I am not finding who the police were. I'm not hearing anything about police prosecuted. Who were the officers? It's just generically 3 individual officers. We're not allowed to know who they are, I guess. Oh, her name is now Linehan. Jessica Linehan. Justice after husband killed. Yeah, okay. So, what is she up to now? And the question is, yeah, Denver Post. Okay, let's read up. Let's see what's going on in the modern day. When was this made? This looks like kind of like an old article. I can't really tell. Crime feed. Aaron, in 1999, Jessica Linehan of Castle Rock was able to obtain a protective order. Physical and emotional harm would result if guns were not kept out of the family's home. Yep. For 10 hours, she phoned Castle Rock police and met 9 times with officers, but they allegedly only did a superficial search for the children, and there was little they could do to call them if Gonzales failed to bring the children back. What? In 2005, she filed a case against the United States with the Inter-American Commission on Human Rights. She asserted that the filings of their inaction violated her and her $3 human rights. Probably is a human rights violation. That police would do nothing to locate Rebecca Catherine or enforce my restraining order. I would have taken the situation into my own hands by looking for my children. So if you just didn't create the false assumption of protection by police, maybe people would do capitalism and go use private sources of protection. But they created the false assumption. In 2011, the commission ruled in her favor and found the U.S. had committed human rights violations. Jesse. Yeah, Jesse's not his son biologically, I think. I can't remember. Or he is the one that was biologically. Her son continued to struggle with PTSD. Of course, it was a horrible murder. She continues to fight for injustice. Wow. Filmmakers. Home Truth. Denver Film Festival. Guess what I'm watching? I won't watch it on stream. That's just not fair. But I think maybe I'll watch it. Okay. Well, I need to leave myself a note right now. I'm going to open up a research document. It sounds like I'm watching this film, and I will try to use clips of it in a copyright friendly way. This will be part of whatever video essay I build off of this. Home Truth, part of the Denver Film Festival. I would desperately love to know more details. I will watch this independently, probably. Home Truth. Okay. So, the police are not your friends. How a mother suffering of policing in America. In America. Cool. Yeah, I'm gonna save this document. And I now know about the existence of this thing. Home Truth. Is it like on YouTube? No, what the hell is this? Denver Film Festival. Home Truth documentary. Sign in. Well, rip. Okay. All right. Well, I'm going to continue my research into her story. I will attempt to retell it in a video as a tool, 100%, using her story as a tool to teach people about the reality of policing in America. What a fucked up case. Oh my God. What percentage of normal Americans even know about this? Well, tell the story. Reform the system. Remind ourselves that a better world is possible and that it doesn't have to be this way. But if we want to rouse people to making those changes, first they have to know how bad things are in the first place. So we will continue as much as we can to say the quiet part out loud. Thank you for watching this stream. If you watched this stream, look forward to the video that will come out of this stream eventually. Take care.